Lord, may I have my lords kind leave to mention, my lord?
Friday, my lord, simply mentioned. This guy mentioned. But say, my lord, we start tomorrow. As a matter for today at the stop.
It will be
Not appear.
that will be taken up. What is the serial number?
182.
I will take it up. Don't worry.
Lord, may I have my lords kind leave to mention, my lord?
Ask intimate him. It will be after how many topic he has bolo. After that it will.
But I'm mentioning for a reason, my lord. The entire
No,
work,
tomorrow. Come tomorrow.
Item number 1.
Item number 1, Lordship, I am for the petitioner in this matter. I am led by Mr. Ashraf Mondol.
What is this application?
This application for restoration of a dismissal order dated 10th December 2024, passed by Honorable Justice Ravi Kishan Kapoor, this Honorable Court. I have
Where is
already,
the affidavit of service?
Lordship, I have already served, but the affidavit of service is yet
Tomorrow.
to be affirmed. Is yet to be
Today.
affirmed.
Not today.
Item number 2.
Yes. Hey, petitioner. Pending. Not today, court. Mentioning is this is the
Time for the petitioner in this application.
affidavit of service.
My lord, I serve the, my lord, an application by hand. But,
State is the only respondent. State is the party only. And private respondents are there.
My lord, here is the, my lord, Pradhan and my lord,
Okay, this is what-
officer is the, my lord, both here, my lord, respondent number.
Where is the service upon Pradhan?
My lord, by hand, I already served to the, my lord, by letter.
What affidavit করতে কালকে দাও day after tomorrow.
Item number 3.
My lord, in item number 1, my lord, I am for the state, but I didn't get the link, my lord.
Tomorrow, not today.
Much obliged, my lord.
3.
In item number 3, my lord, I am appearing for the petitioner, my lord. This is the affidavit of
My lordship, my senior is engaged in court number 14. I
This
should
is
pay
for the
third
extension
party.
of interim order, my lord. This is only for extension of.
Yes. এটা কি অ্যাপ্লিকেশন আছে there is no application.
My lord, because, my lord, I'll tell your lordship. My lord, on Friday, my lord, I have mentioned the matter, my lord. But your lordship, but your lordship directed to mention it on Tuesday, my lord. That's why, my lord, I was mentioning on time, my lord, but your lordship has directed to mention it on Tuesday, my lord. Your lordship will consider. So I've mentioned on Tuesday, my lord, and Wednesday the matter was in the list, my lord. But it is taken up today, my lord. That's why, my lord, we have not filed application, my lord.
সেদিন ওই অ্যাফিডেভিটের সার্ভিসটা রেডি হয়েছে, আমি তো ভেবেছি কোনো অ্যাপ্লিকেশন আছে। ফার্স্টে ম্যানেজার কবে এসছে দেখো তো লিস্ট।
My lord, it was heard by Honorable Judge Sugato Mujumdar, my lord.
when we to is listed after, কবে মেনশন হয়েছে কবে লিস্ট হয়েছে, মেনশনটা কবে হয়েছে কেন, এই তো মেনশনিং অলরেডি এক্সপায়ার করে গেছে।
Hello.
7 days stay was granted.
My lord.
Huh?
My lord.
You have mentioned on 12th March.
No, my lord, but I mentioned on Friday, my lord. That is one, my lord.
Which Friday?
My lord, I have mentioned on time, my lord. But your lord,
Which Friday? Your mentioning slip is 12th March.
my lord, the matter was taken up on
12th এ মেনশন করেছে, 13 এ এসে 13 এ অ্যাফিডেভিট ছিল না, এই তো ওয়েডনেসডে মেনশন করেছে। দেখেন 7th March ছিল, একটু দিয়েছে 7th March. Who is for the state?
My senior is engaged in court number 14. I prefer short passing.
Who is your senior?
Advocate Shuma Chakraborty.
What is this case?
this case is about, my lord, illegal construction, my lord. But your lordship, I have challenged the notice, my lord. And it was heard by Honorable Justice Sugato Mujumdar, my lord. Senior advocate Shoptangshu Bosu was appearing, my lord, in this matter, my lord.
Ask your senior, pass over করে দাও। Ask. তখন দেব। Pass over.
Item number 4.
এটা দিয়ে দাও, অ্যাফিডেভিটের সার্ভিসটা দিয়ে দাও তখন। দিয়ে দাও ওটা। দিয়ে দাও, আরো আগেরটা দিয়ে দাও তো। ভারতীনের স্লিপ আছে, কিন্তু ওর নোটিশটা দিয়েছে 7 দিনে। যেহেতু আমরা পার্টস চেঞ্জ করেছি না, ফ্রাইডে মেনশন থাকে না, বুধবার দিন সোমবার দিনও পাইনি, মঙ্গলবারটা মনে বাদ গেছে, বুধবার দিন মেনশন নিয়ে নাও, এক্সটেন্ড করে দিই, একটা শর্ট এক্সটেনশন করে অ্যাফিডেভিট ডিরেকশন দিই। State, you are for the state?
I'm sorry. My lord, this is my lord, second round of litigation. My lord, second round of litigation, my lord. First round, my lord, an order was challenged, my lord, for seeking quashing of the, my lord, rejection of compassionate appointment of the petitioner. My lord, whereby an order has been passed granting liberty to file a case. May I, my lord, in short, my lord, may I tell, my lord, father of the petitioner was an executive assistant in the concerned Gram Panchayat. While he was working, my lord, he died in harness on 18th of September 2009. Soon thereafter, within the prescribed time, application was made seeking compassionate appointment. That was on 6th of January 2010. The application was kept pending. And ultimately, my lord, on 27th April 2023, at least 13 years after, my lord, the rejection order came out that there is no ground for, my lord, giving compassionate appointment. We have challenged that.
On 23 order was passed.
Order was passed by the authority. Communicated. Page 44. On the ground that there is no need for immediate financial assistance. In 2023, they say, my lord, there is no need of immediate need of financial assistance. Page 44, my lord.
Page
P12.
44.
It is dated, my lord, 27th of April 2020. My lord, straight away come to the middle portion. It is rejected on the ground that there is no need for immediate financial assistance as it is evident Siemens committee such and such report. In 2023, they say, we challenge that. My lord, the next page to next page, my lord, page 46. Page 46.
So page 45.
45, it was dismissed for default, but subsequently it has dropped.
This is another application.
Previous writ petition. Where, my lord, this challenge was made to this, my lord, this order. This 2017 or 2013 order.
But then another writ petition has been filed 20794.
Another writ petition was filed. It was dismissed for default, and subsequently, my lord, fresh writ petition was filed. Challenging.
How could the other writ petition not restored and thereafter you?
It is maintainable. There are judgments. It is maintainable. If
But this was not brought to the notice of the court that previously are dismissed for default.
perhaps it has been mentioned, my lord. And in that matter, my lord, I was not there. The next page, page 46. Page 46 is the order passed in the writ petition to file the report, my lord. Kindly, my lord, have a look to page 46A. The penultimate paragraph. Compassionate appointment is the benevolent policy of the state. Privacy, the record shows that there was no contemptuous response from the state authority after receiving the application from the petitioner in 2020. The impugned rejection does not show that the case of the petitioner was rejected on any disqualification ground, but due to passage of time. The passage of time, in fact, of this case, prima facie appears to be not on the part of the petitioner. And thereby, my lord, a report was called for. And my lord, next page, page 47 is the report. The it is in the former affidavit. The actual report, my lord, will find in page 52. That is Grievance Committee. First of all, my lord, my lord, go to page 52. First of all, my lord, the report is undated. When the inquiry took place, when it was inquired, nothing was disclosed. Even after the signature of the alleged grievance, my lord, members of the grievance committee, no signature has, after the signature, no date, nothing. Even the affidavit in the form of report, it does not say, my lord, when the inquiry took place or
The inquiry report has signature.
yes, my lord.
Inquiry report has a signature.
Signature without any date. When it was inquired, that was not done. First, a second, my lord, will find from page 52, columns C, under column C, under the head total monthly income in middle portion. Under the heading total monthly income,
In which place?
page 52. The inquiry report. Total monthly income. Under the heading monthly income from movable and immovable properties. A four-wheeler Tata Sumo bearing number such and such used for commercial purpose, 5,000 approx. My lord will find in the last page of the brief, page 65. My lord, kindly tally the vehicle number has given. WP 282093. With the, my lord, page 65, that is WP 282093. It is a two-wheeler. page 65. It is government application. How the inquiry has been conducted. They say Tata Sumo, monthly commercial activities and all things like that. But it is a two-wheeler, motorcycle, scooter, two-wheeler. First, and thereafter, my lord, the next page, my lord, will find page 53. Column 4, income from land, 3,000 quarter yearly. These things are, my lord, quite not understandable. Where from they got this? And my lord, when this report was produced before the in the previous litigation, my lord will find page 63. Order was passed directing us to challenge the report and its consequential. That is why this the petition has been filed, challenging the report and its consequential. Fine. The order dated 12 November 2024. In view of the stand taken by the state and the contents of the inquiry report, WB such and such can disposed of by granting liberty the petitioner to file writ petition afresh challenging the inquiry report and its consequential steps taken by the state in accordance with the result. That is why, my lord, this writ petition has been filed. So, my lord, at this case, I would pray, my lord, was the inquiry report, let a fresh inquiry be conducted, and accordingly, on the basis of that, my lord,
File your affidavit.
Court kindly considers the bone of contention of the petitioner is there are two heads. One is income from the land and income. One inquiry report has been given by the state authorities. Let a
one
report,
minute,
let
may
a-
I- yes, yes, yes.
let a report may be stated clarifying the stand about those two aspects only. If those two amount of 5,000 and 3,000 goes, then the petitioner has got a good case. But this document which has been annexed, the authenticity of this document has to be verified and certified by the state authority. This is a document which has been downloaded from somewhere. I do not dispute for the time being, but this has
is
to
Bahul
be,
Parivahan.
this has to be
This
a
is
sacrosanct
central-
document.
Central government website, not everybody knows. This is
But
now the app.
again, while providing such documents, proper valid certification is also required to be provided. That hasn't been done. Anyway, I'm not going into that. Let a report come in respect of these two aspects, that whether what is the stand in respect of the income from land and from the motor vehicle. If the state records provide otherwise, then it's a different case.
And other
Hmm.
thing, my lord,
Awesome.
other thing,
Awesome,
the
awesome.
petitioner
You'll be filing a
suffered
report or a affidavit?
Report, Your Lordship.
in the form of report. And other thing, my lord, the medical expenses of the petitioner's father was not
Awesome, awesome.
also taken into consideration.
Affidavit of service filed on behalf of the petitioner is taken on record. This writ petition has been filed. For cancellation, and or rescission and or withdrawal of the inquiry report of the state authorities. The petitioner is the son of deceased employee of the Panchayat. Which Panchayat this is?
It is, my lord,
Of the Badkulla 2 Gram Panchayat,
under Haskali Development.
who
Board.
died in harness on 18 September 2009. Stop. The petitioner applied for his appointment on compassionate ground on 6 January 2010. However, the same was rejected. Which is that order?
My lord, on it is at page, my lord, 34.
34.
44.
Order.
Dated 27th April 2023.
The same was rejected on 27th April 2023. On the ground that there is no need for immediate financial assistance as per the three-man committee report. Challenging such action of the state authorities, the petitioner filed a writ petition.
46 months.
No, the earlier one.
My lord, perhaps, my lord, it was dismissed for default prior to, my lord, issuing of the rejection order. That is why perhaps, my lord, it was not
Might
restored. And by that time, I was not there.
Hmm.
This petition has been filed challenging the press conference.
That might be the case that since the appointment was not made, they could have filed a writ petition for expeditious disposal of your application in 2019.
19 application was made. I don't know, my lord, I haven't.
You have a copy of that?
No, my lord.
But
So
then find it out.
we'll try, my lord.
Challenging this order of rejection, the petitioner filed a writ petition being WPA number 20794 of 2023. The said writ petition was disposed of,
On my lord,
granting liberty to the petitioner to file the writ petition afresh challenging the inquiry report. Hence this writ petition. Mr. Uday Narayan Betal, learned advocate appearing for the writ petitioner, submits that the inquiry report is undated. Full stop. Furthermore, the vehicle, as mentioned in the inquiry report, is a four-wheeler vehicle. However, from the document of registration certificate status downloaded from Bahan in italics, the said vehicle being number WB28-2093 is a scooter and not a four-wheeler. Further, the income from landed property, as noted in the inquiry report to be rupees 3,000 yearly, is without any basis.
but, my lord, text page 65. Owner's name is, my lord, height, but still the words appearing, my lord, it is not in the name, neither in the name of the petitioner or
The
Yes.
vehicle is also not named. Vehicle does not stand in the name of the petitioner. Hence, the inquiry report is not proper. He seeks for quashing of the inquiry report. Mr. So-and-so, on the contrary, Mr. So-and-so, an advocate appearing for the state respondents, seeks to file report in the form of affidavit.
Report would
No. Somebody has to come and say that it is correct, not a report in the form of affidavit. That's why I was asking you whether we will file an affidavit in opposition.
In the form of affidavit.
Report in the form of affidavit.
Another thing, my lord, the medical
Let such
expenses of the petitioner's
report in the form of affidavit be filed by station within 2 weeks. Advance copy be handed over to learned advocate for the petitioner within a handed over. Stop. Exception to such report, if any, be filed within a week thereafter. Yes.
my lord, the medical expense, father, my lord, suffered, my lord, cancer, and thereafter, my lord, died. Those medical expenses also, my lord, not looked into the report, or we are, since it was hard expertise or inquiry report was.
Let them come up with the report. If
I
you
will
find
file
anything
exception. Matter will appear, my lord.
after 3 weeks under the heading returnable motion,
My lord, at top, my lord.
let it come up. It cannot come. Let it come up first.
As in the, sir. Grateful.
Item number 5.
आगे ये दे दें तो पास ओवर. Pass over. Just a minute, Mr.
Passover matter 3.
Sir, for the state, my lord. But on last occasion, you.
Where is the petitioner? Okay. ये तो वो
Lordship shifted this case in the regular bench last occasion. Lordship directed on 20th February, 28th February 2025.
I am
my lord.
appearing for the petition in this matter.
The matter is transferred to the regular bench.
regular bench. Whom order? Which order?
8th February.
But passed by the Honorable Justice Shugato Mujumdar, my lord. As the lordship was not there, my lord.
Wait. एक ही कुछ. That will place your regular bench. Follow. Will be filing any report in this?
My lord, no report has been filed because there is a clear, come to the annexer. We have annexed in this writ petition, my lord, 76 and 77, my lord. It is very much clear that Gram Panchayat has conducted a spot inspection on 2nd January 2024 and found there is a illegal construction as there is no plan has been shown, and that's why the demolition order has been passed, my lord.
More
So
so, my
now
lord.
they are challenging that has.
More so, my lord. In section 23,
Where is the order?
page 77, my lord. The reason order.
I am stating page 76, my lord.
Advocate return the petition not serving notice in proper time and
During hearing, private
but
respondent.
expert is highly deprecated. The appearance of the made on behalf of the party. The stands affirmed. The notice.
73, page 73. Honorable Justice Amrita Sinha has passed order on 10th October 2023, and accordingly, PDO has considered the representation and has taken steps. Now they are challenging this order in this writ petition.
My lord, may I, my lord?
Yes.
My lord, if your lordship kindly comes to page 77, my lord, the reason order. My lord, may I read, my lord? Whereas Honorable Justice Amrita Sinha directed to Sonajudi Gram Panchayat to consider and dispose of the representation dated such and such, Midday reference number such and such, whereas in compliance of the order of Honorable Justice Midday such and such, Gram Panchayat conducted a hearing on 28th November 2023 and spot inspection on 2nd of January 2024 in the presence of the petitioner Rupchand Gorain and private respondent Somnath Sen, son of Vishwanath Sen. During hearing, private respondent Somnath Sen failed to submit any permission from the Sonajudi Gram Panchayat to make construction over the plot number 103, 104, 105, 107 and 108. Moja Kalipur, jail number 43 and petitioner Rupchand Gorain submitted field inquiry report from the office of the block land and land reforms officer Purulia 1. Apart from that, as per order of Honorable Justice Sonajudi Gram Panchayat conduct a spot inspection dated 2nd January 2024 and found that a construction was made over the land of plot number such and such without obtaining any permission from the Sonajudi Gram Panchayat. So after scrutinizing all the records, Sonajudi Gram Panchayat hold a general body meeting dated 5th of January 2024 and passed a resolution that construction over the plot number such and such of said Moja can be demolished as per section 23 of the West Bengal Panchayat Act 1973, Malad. If your lordship now kindly takes the section 23, Malad, once.
The yes.
Malad, kindly comes to section 23(5), Malad.
Yes.
Malad, Section 23(5) of the West Bengal Panchayat Act 1973 deals with the consequences of erecting or making addition to the structures in contravention of the provisions of subsection 1. The permission granting authority must refer the matter to the subdivisional
So
officer.
writ petition is disposed of giving a direction upon the
My
Pradhan?
lord, my lord, but my lord, kindly, my lord,
Yes, very good.
that order be stayed, my lord.
No stay.
My lord, but my lord,
He will be directed to accordance of 23(5).
my lord, kindly, my lord,
Aswan.
my lord, kindly,
Now,
my lord.
since you have come, there is order of the court that has been complied. Only 23(5) has to be
My
complied.
lord, but my lord,
He will not
that
proceed.
order should be stayed, my lord.
No.
Kindly, my lord.
No stay. No. This affidavit service filed on behalf of the
My lord, then my lord, they will take
Please,
care,
sir,
my lord. My lord,
is taken on record.
as your lordship. My lord, kindly.
This writ petition has been filed for cancellation and or rescission and or withdrawal of the impugned order under memo number 5/SGP/2024 dated 8th January 2024 passed by respondent number Pradhan is
My lord,
Pradhan is respondent number
6.
6.
Pradhan Sonai Juri Gram Panchayat.
Sonajudi.
You have written here Sonajudi.
It will be Sonajuri.
Sonajudi is here, there. Sonajudi.
Sonai Juri Gram Panchayat. Huh? This is second round of litigation. Previously, a writ petition was filed by Rupchand is private respond number?
7.
7, my lord.
Private respond number 7 being WPA 12144 of 2023 alleging of illegal and unauthorized construction at the behest of the petitioner hearing. Upon hearing the parties, the writ petition was disposed of as follows. বলে এইখান থেকে ঠিক আছে, এই দাগ দিয়ে দাও, এই কনস্ট্রাকশন অব্দি। The principal contention of the petitioner is that the respondent number 6 Pradhan, Sonai Juri Gram Panchayat, has passed order observing that the construction can be demolished as per section 23 of the West Bengal Panchayat Act 1973. Learned advocate representing the petitioner submits that as per the West Bengal Panchayat Act 1973, the Panchayat Pradhan Gram Panchayat has to refer the matter to the subdivisional officer in terms of section 23(5) of the Act of 1971. West Bengal যেখানে বলছে ওখানে hearing have to refer to as Act of 1973. Hence, the impugned order is bad in law. Ms. Soma Chakra, on the contrary, Ms. Soma Chakraborty, learned advocate for the
Jhuma Chakraborty.
Soma.
Jhuma, J-H-U-M-A.
Oh, sorry.
Fine.
Jhuma Chakraborty, learned advocate representing the state respondents, submits that the impugned order of the Pradhan has been passed in compliance to the order passed by this court in the previous writ petition being number 121, what number? 44 of কোথায় গেল আরেকটা?
Page 73, my lord. 144 of
12144 of 2023, my lord. Page 73, my lord.
She also submits that the Pradhan be directed to take recourse to section 23(5) of the Act of 1970. Upon perusal of the impugned order of the respondent number 6, Pradhan Sonajuri Gram Panchayat, it is found that upon scrutinizing of the records and conducting a spot inspection, it has been found that the construction over the plot of land being number 103, 104, 105, 107 and 108 under Mauja Kalipur, jail number 43, has been undertaken by the petitioner without obtaining any permission from the Sonai Juri Gram Panchayat. Be that as it may, it has been observed that the Sonai Juri Gram Panchayat, upon holding a general body meeting on 5th January 2024, passed resolution that the construction can be demolished as per section 23 of the West Bengal Panchayat Act 1973. Since it has been argued that the order is bad in law, since section 23(5) of the Panchayat Act 1973 has not been taken recourse to, it is clarified, the writ petition is disposed of, clarifying that the Pradhan respondent number 6, Sonai Juri Gram Panchayat, shall take recourse to section 23(5) of the West Bengal Panchayat Act 1973. With the aforesaid observation, the writ petition stands dismissed.
Deeply obliged. my lord.
Next.
Item number 5.
This is my matter relates to the removal of the Sanchalok and the members of the Uposhamiti of Gram Panchayat. Your Lordship, straight away come to, please, my Lord, first annexure, page 12. This was the requisition notice by the members. In the first paragraph, the Lordship kindly says, we the elected member of Gora Pasla Gram Panchayat would like to bring you before you and seeking your necessary action for removal of all members. All, your Lordship kindly mark this portion. All members, including Sanchalok of all 4 Uposamiti. On the basis of this requisition, the prescribed authority, your Lordship kindly come to the
all were elected
page
the last
16.
Party and total 22 elected. That as per provisions. Confidence motion due to that. Yes.
All 4 Uposamiti and all members of the Uposamiti. Now, page 16. This is the notice of motion issued by the prescribed authority fixing the date today, serial number 3, today 17/3/2025 at 12 p.m. against all the members, including the Sanchaloks. There are 9 in number. This is under challenge before your Lordship. Now, your Lordship kindly sees the law. Against all, in a single requisition or in a single motion, cannot be. And since it has been decided by this Honorable Court on several occasions, I may not believe
No, this no confidence motion has been moved by whom?
by the members, the Gram Panchayat.
To
The
remove the Pradhan.
Remove the Sanchaloks and the members of Uposamiti. In every Gram Panchayat, there are 5 Uposamitis.
Okay.
But Ortho Porikalpana Uposamiti cannot be touched because Pradhan is the Sanchalok and Upapradhan is the Vice Sanchalok. That cannot be removed. Now, other 4 can be removed. But for the purpose of removal of the Sanchalok, the constitution of Uposamiti has to be followed. Well, Uposamiti, one by one, it is being elected. The removal is also has to be one by one, not in a single day, in a single motion. That is the observation of this Honorable Court. Your Lordship kindly sees this.
Now, what is the provision you are indicating?
Gross separation of material facts, we are not acting on that requisition notice. Because that is a defective one. That's why we have not touched it. We have not processed it. What my learned friend suppressed, that another notice on 22nd February requisition notice has been served. That is, Malad, after being satisfied in terms of Rule 22(5), Rule 22(4)(b), Lord, we have sent the statutory notice. After convening the meeting today. Gross separation of material facts. 22nd. This is the notice, requisition notice. My learned friend has not annexed it. Gross separation of material facts. We are acting on the basis of this notice, not the notice which have been annexed in the writ petition. And the previous notice was, my lord, defective on 3 scores. That's why, my lord, the prescribed authority, my lord, has not been satisfied, and that's why, my lord, no action was taken. My lord, second, my lord, notice, requisition notice has been no confidence requisition notice has been received on 22nd February,
Hmm.
and we have acted upon it.
The motion.
And with the Milord statute says, within 5 days, prescribed authority should convene a meeting. Not complying with the statute, we have convened a meeting.
Yes. Today is the day for convening the meeting against all. Now, your lordship kindly peruse this.
But we are acting on the basis of the 22nd.
Very well, very well.
Notice,
But
not that notice.
motion is at page 16. I am challenging that.
Yes.
Your lordship kindly peruse this judgment. And
Because I am
followed by
protected
this,
by recent
another
judgment.
judgment. কোনটা দিলাম? হরি সিং, আগে কোনটা দিলাম? Followed by that judgment, another judgment has been passed by the
Rule
Honorable Court.
5, Rule 5.
এটা একটা দিয়ে দাও।
Judgment.
Because
Take
these
me
two
through the
judgments-
provisions first.
Yes, Lord.
22-4. Has you not got it? Rule 22-4. West Bengal Panchayat Constitution Rules 1975.
Well.
22.
Provision, West Bengal Panchayat Constitution Rule 1975. Rule 24 F provides.
That has been annexed in my note, Milord.
এটা দেখাচ্ছি। আপনি ঠিক করুন, আমি বলে দিই, আপনি আবার দেখান। আপনি বলে দিন, আপনি বলুন। আপনার reply সব বলুন।
West Bengal Panchayat Constitution Rule 1975.
Yes. 4, 22-4.
24.
F provides. Provided that
Yes, বলো দেখি। Provided that.
yes.
And if a
The
meet-
meeting is convened to consider the motion to remove more than one member or Sanchalok of on Uposomiti or more than on Uposomiti, the motion shall be taken up for consideration one after another in the same order as mentioned in subsection 2 of section 32. But one after another, every member, every Sanchalok. Where is that? They have convened this meeting in a single notice saying 9 mallet person, out of them 4 is Sanchalok, 5 is
remove more
member.
than one member. No, where is the provision that separate notice has to be given?
There is no such provision.
One after another means
One after the other means if a notice is given, suppose of 5, more than one.
Yes.
So one after the other, the matters will be considered in the meeting.
time is only 12 and notice is against all. Member, Sanchalok,
If the
everyone
motion
is
or carry
sought
major-
to be removed in a single motion. That is bar. And that has been decided by this honorable court.
But if your lordship kindly reads the proviso, your lordship would see the word motion is there, not motions.
Motion, on motion. Here on motion.
The motion shall be taken.
in
And
every
statutory notice,
motion, on will be removed.
One if your lordship
Sanchalok in
kindly
on motion, member in on motion. But for Sanchalok in a on motion, it is absolutely bar. That is decided in this judgment.
No, no, in one motion, the more than one members cannot be removed. But the proviso says so. Proviso to 22F says so.
Why so? If the meeting is convened to consider the motion
Huh.
to remove more than one member or Sanchalok of on Uposomiti or more than on Uposomiti, the motion shall be taken up for consideration one after another. The motion,
Hmm.
this is on motion. Motion shall on after another. This notice of motion is for one. Motion shall be on after another. One for on Sanchalok, one motion, another Sanchalok, another motion. The meetings cannot be clubbed together in a single day, single time. সেগুলো আবার আলাদা হয়ে গেল। তুমি করছো।
This notice has been given under which rule?
22(4),
Both C,
4C, and if your lordship value takes the form 1F.
both C.
No, let us first understand this, whether separate notice is required for moving separate motions against, whether in a single motion you can remove. That is to be decided.
It would be taken one after another.
But what about notice? He says that all the notice should be separate notice.
It would be-
Motion would be,
Motion would be-
separate notice has to be given to each of the, I mean, the requisition
Yes.
for removal would be separate.
Requisition has been received, and Milord, we have the prescribed is satisfied,
That is not disputed. You have received, you have
and it
done
has
your
been
job,
sent-
but
it has been sent
this is
to
wrong.
the registered post, and we also.
You see this order which he has placed?
Yes, Milord, we have, but that has been referred and
He is
discussed.
aware of this.
Milord, recent judgment, Milord, I am protected by recent judgment of this honorable court, and this was appealed in the appeal court also. Recent judge. Which is Judicial judge. And Milord, principle is this, Milord. Majority should be tested at the floor of the house. Why is he shy away from the floor test, Milord?
Let there be further requisition. I will have the courage to test them. That has to be done.
Judgment chamber. এবিটিটা দেবে একটু বার করে দিন। Kindly sees the division bench judgment. What is the law decided? Milord, we have soft copy. If your money, if your lordship's court officer can take the Milord, print out your lordship.
Which judgment?
Appeal has been preferred against this judgment.
Milord,
The judgment, Milord, case I have referred. to
there
the
are
lordship.
two judgment I have referred, Hori Singh
MAT,
and Montu Sarkar. This has never been challenged. It's so for my knowledge.
MAT 20. MAT 20 সেটা
কি বলছি?
নাম্বারটা একটু দেখুন। নাম্বারটা লিখে।
Yeah.
Your lordship has seen the statutory notice, which is at page 16.
I have, sir.
একটু বলে দিতে তো বলা হয়ে গেছে। Your lordship has seen page 16,
Is 16 of?
This is a statutory notice, in terms of form 1F.
In terms of 22 votes.
Statutory notice. This is the notice, statutory notice in terms of form 1F. Because this is the notice, and it will be taken one after another. First, it will be Sagar Prasad Chowdhury. Second, will Samakti Mondol, Saptami Mondol. Third, Monira Khatun. By this special billot, it will be taken up one after another. But the notice would be a billot single. Yes,
Notice will be single.
lordship. But it will be
Yes,
taken one
for
after another.
removal was on the requisition brought by members. A single notice, a single meeting for removal of all censures are notified.
So the agenda is same. It will be taken one after another. And this is the judgment I have cited, not single bench judgment that has been upheld by the Honorable Division Bench. This is the latest judgment. And principle of law has been discussed. Majority should be tested before the floor of the house.
No, he is not on that whether it will be tested on the floor of the house, whether the notice is proper.
What is this proper, my lord?
How? Now here it says the judgment of Justice Sarkar, Montu Sarkar. This has been set aside on the ground that the notice was issued in respect of all the three Upa-Samitis. Huh? See this and then you make your submission. Come to page 2 of that. And B, the irregularities have been noted. B is the relevant one. By a single notice, a single meeting for removal of all Sanchalaks of all the three Samitis was notified. Separate meetings for removal of Sanchal different persons ought to be notified with separate timings.
হরি সিংকে ফলো করে এটা also granted liberty to the requisitionist to have the fresh motion.
On the strength of the confidence, we should separate notice. That no confidence, but on second February. Which I have handed over to your
Only we are concerning about 16, only 16, page 16.
Your lordship kindly takes page 12 of the requisition. As your lordship, page 12. Because this is the note, no confidence requisition notice, on 21st November 2024. We are not acting upon this. We are acting on a different notice, 22nd February. That has not been suppressed. On that score alone, your lordship kindly dismisses the petition. That has not been, this is not brought to your lordship's knowledge, my lord. Judicial, it is not within the judicial record, my lord.
Yes.
That on that score, it should be dismissed.
21st.
Frivolous
This
petition
notice
suppressing
was served on the Sanchalak and the member. 22nd, another notice that has not been served upon us.
That
How
has
can
been,
how
yes,
could
yes,
we
that has
know?
been served. Your
Let
lordship,
them come with the affidavit saying that it has been served.
the
on-
meeting would be held today.
I have been served this
Meeting
notice
would be held.
and I have been served
Why
this notice by the
suppression of material facts?
prescribed authority. If that be served, why should I suppress this? I have come forward with this notice also. I have come forward with this notice. I am challenging the action of the prescribed authority, whether he can act on the basis of the requisition, whatever it is 21st or 22nd, against all, whether it is justifiable or not. That is the contention before your lordship. If it is not sustainable in law, then this notice should set aside. Suppression, all these things, these are not correct. I have been served another notice. If it would have been served upon me
I would have come forward with this also, annexing that notice also. But since the action of the prescribed authority is under challenge, this is not under the law, well, it has to be set aside. That is my submission. And the law is settled, well, different judgment has been passed by this.
Yes, sir.
I have challenged the requisition, motion notice of prescribed authority. Only this.
Your lordship kindly takes P1.
ये तो reply,
This has been-
for reply হচ্ছে
This has-
হ্যাঁ তো শেষ endless
তুমি যদি রানিং কমেন্ট্রি করে তাহলে তো বুঝতে পারবো না
reply for reply হয়
ডিসেন্সি মেনটেন কর কোর্টের ডেকোরাম আছে সেইটা মেনটেন কর সেটাই ভুলে যাচ্ছিস your lordship has seen below P1 below this
Well,
is the below no confidence
there is a very specific
Wait,
below if I am not allowed below
sorry, ma'am.
if, if your lordship kindly sees P1 below this is below no confidence motion below they are harping on it and they say this clear cut below specific averment is that following this below no confidence motion this below statutory notice has been served. But our specific contention is this below we are not acting on the basis of this notice below because it's a faulty one. We did not take any steps. Below we have received a fresh notice which has not been challenged before your lordship, not been annexed before your lordship. As a fallout of this notice after being satisfied by the prescribed authority, this statutory notice has been served. So below on the ground alone for suppression of material facts and not bringing that document before your lordship, below this statutory notice form 1F cannot be challenged. As a fallout of the 22nd February's notice, this statutory notice has been served. That has not that is not before your lordship. It is a gross suppression of material fact, to mislead ruling this honorable court, deliberately this has been done. No proper cause of action arises, You have seen so 22nd February requisition notice, which I have handed over before your lordship, As a fallout of the aftermath of that no confidence motion, this statutory notice has been challenged, sent. But since that has not been before your lordship's consideration, that has not been challenged. This repetition should be dismissed in limine, because of suppression of material by not bringing that notice. We are acting on the basis of that notice. Kindly seize, kindly seize the averment they have made. Kindly seize.
they say that this has been served upon them?
Yes.
When?
You kindly seize my first page. It has been served upon them. He is not saying that has not been served. He is only considered contention is challenging that statutory notice. That statutory notice is a fallout aftermath of that requisition meeting, 22nd February. That has not before your lordship, Gross suppression of material fact. It has been served by applicants through postal receipt attached and also by hand. Thereafter, it has been affixed as at conspicuous place for their premises, of their premises. I have the documents with me, sir.
Where is the document?
This is by postal receipt as well also by hand. On the ground of suppression of material fact, your lordship should dismiss this petition. Paragraph 7, your lordship kindly says.
No, where is the document of this has been served?
Yes, But Not kindly, first page of my summary and brief history, your lordship kindly takes first page of my report. Point number 3. As your lordship
Where is the endorsement of the petitioner having received the notice?
Yes,
Where is that?
yes. Postal receipt attached is, postal receipt is attached there.
দেখাতে হবে না, where is the postal receipt? Who are the petitioners herein?
Petitioners Saptami, Munira and Sagar Prasad, they are the Sanchalok of 3 Upashami.
This is the postal receipt. Just statutory notice. This is the postal receipt.
I don't know what is the
All the
date,
members.
what is the date of that is.
Postal receipt and hand service is also there. Their signature, your lordship has already noticed. They have received by hand, my lord. By hand delivery, my lord. That is also annexed there. By
You are moving the motion against Sagar Prasad Chaudhary,
Yes.
Saptami Mondol. Where is the hand endorsement of these persons receiving the notice?
And also as well as, my lord, last annexed postal receipt.
Munira Khatun. There are 3.
Saptami one. And another thing, my lord,
This thing, enclosure 3, it is signed by the persons who have moved the motion,
Requisitionist.
requisitionist. Where is the document that they have been served with this notice, which you could have
lord, I have already handed over it.
hand service?
Yes. Lord, this is the respective signatures, my lord. Lord, this is their respective signatures. At column 3 or 4, my lord. Last signature here under the heading signature, my lord.
These are also requisitionists.
Lord, another thing, my lord, if your lordship kindly takes the statute law, Lord, lordship kindly sees 22.4. Says any one member, more than one member, or all members of the Sanchalaks of an Upashamiti, more than one Upashamiti, or all Upashamitis other than the Sanchalak or of the Ortho Porikalpana Samiti may at any time after 1 year from the date of constitution of or reconstitution of such Upashamiti, or in case of any individual member from the date of his election as a members of Upashamiti be removed from office by a resolution of the Gram Panchayat. As your lordship kindly takes B is a satisfaction. It depends upon the satisfaction of the below BDO C. And your lordship kindly takes D. The meeting referred to sub notice shall be held on a working date which shall not be later than 15 working days. So, my lord, my learned friend, my lord, is challenging a requisition notice, my lord, which has been served on 22nd November. And my lord, prescribed authority, a duty cast upon this prescribed authority to act within 15 days. So, my lord, in any event, my lord, the statutory notice could not have been, my lord, issued, my lord, on, my lord, 27th February. My lord,
My lord, may I reply to him, my lord?
No,
This
my lord,
will be
sure.
endless. This will be absolutely
Could not
endless.
have been, my lord, issued on, my lord, on, my lord, 28th February 2025, within 15 days, my lord, statutory period. He is referring a requisition, not with motion, my lord, on 21st November. On that score also, my lord, your lordship kindly dismisses the petition. And paragraph 7, what kindly sees what is creating averment, that your petition, but page 6, that your petition states that the prescribed authority, after receiving the alleged illegal requisition notice on 21st November 2020, chose to issue notice on 22nd February. Paragraph 7,
Okay.
scheduling date of motion on 17th March 2025. Paragraph 7, there is the mention of the Millard fresh notice, which has been issued on Millard 22nd February.
Okay.
My lord, may I reply?
And you kindly sees the prayer, Millard.
B, prayer B.
Prayer B, C,
B, only B.
Millard, cause of action arose after Millard the no confidence motion which has been received by the prescribed authority. Not prior to that. On that ground, Millard, suppression of material fact, your lordship kindly dismisses the petition because it
Yes.
is not before your lordship on record.
My lord, my challenge is the notice of motion issued by the prescribed authority. I sought for the setting aside of this notice because this notice would not have been served upon us, saying that all the Sanchalok shall be removed in a single motion. That is my contention. In so far the requisitionist claim, I have no, my lord, allegation against them. They being the majority, they can seek removal at any point of time. My lord, whether it is of 21st September or it is 22nd September, it is immaterial. The whatever may be the requisition notice that has been acted upon by the prescribed authority. Prescribed authority under the statute is the authority who shall take the decision. Now the prescribed authority has to do his job within the four corners of the statute, not beyond that. The statute has specified 4C that motion has to be in form on F for every motion. And in F proviso, motion has to be one after another. Now prescribed authorities notice
Issue of notice with the item of agenda in form F.
he has to satisfy that the motion, requisitionist motion is correct or not. In page 16, your lordship kindly sees there are 9 numbers of people
No.
to be removed.
The block development officer is to consider the notice today. I mean the requisition made by them. Whether it is proper or not, that is to be satisfied in terms of 22(4)(c). He has not decided your removal.
Decided, it will
First
be
of all,
decided
the
today.
notice, the requisition made, whether it is in proper form or not, that is to be satisfied. He gets satisfaction of that. Thereafter, he will proceed for removal.
My lord,
Correct?
he has
If-
proceeded.
If this goes against you, supposing for the sake of argument goes against you, you have a appeal before the SDO. Within 30 days, you can prefer an appeal. So you are apprehending that there will be removal on the basis of. Let the BDO take a decision on this.
My lord, today is the
If it is not in form, Then he has to decide first
My
whether the notice or the requisition is correct in accordance with law or not.
My lord, the motion, notice of motion is
We
illegal.
cannot go beyond the scope
My lord,
of the writ
notice-
petition.
Notice of motion. This is page 16. This is absolutely illegal.
Hmm.
That has been decided by this honorable court.
Hmm.
In a single notice of motion, whether all the members can be removed. Requisition notice may be one, but he has to send separate motion
I will
notice.
observe that the previous requisition notice has lost its force. What you have prayed, it has lost its force in terms of that order.
Well, I have prayed, your lordship kindly come to my prayer. I have prayed.
No, Mr. Islam,
My lord,
we cannot
kindly,
extend this.
my lord,
No.
This is my lord.
This will be against it. Something.
They read in
which
the
has not
letter of
been-
mandamus
No.
commanding the respondent, their agents, employees to cancel and withdraw the purported notice of motion
Hmm.
dated 28/2,
There can be
2025.
a direction upon the block development officer, which is the prescribed authority, to decide that motion in accordance with law. As far as the other aspect 2111 motion is concerned, that has lost its force.
That is not the motion, that is requisition.
Requisition.
Motion is of 28/2.
Okay. Let
This
him
is under
decide in
check,
accordance.
your lordship.
No. Ashwin.
There is
The-
two
Where
separate
is your affidavit?
requisition notice and motion. Motion is under challenge before your lordship.
কি বললো? Affidavit of service?
No, sorry.
Affidavit of service filed on behalf of the petition is taken on record. This writ petition has been filed for cancellation and or withdrawal of the purported notice of motion dated 28 February 2025 issued by prescribed authority and block development officer Novogram block Murshidabad. Mr. Rabiul Islam, learned advocate for the petitioner, submits that different orthomonology. What is the date of that? 22nd February? Okay. When is the 15 days going to over?
That has not been served upon us.
If it is not served, then you serve that and give separate notice of removal. Mr. Mitro,
Lordship, my lord.
I think the BDO has to issue a separate notice of removal.
Yes, that has been served. Your lordship has seen postal receipts are there, and as well as my lord, by hand
No, this has to be separately given. Sagar Prasad, Din Saptami, all has to be separate. No, this he is correct. I think that is correct.
Your lordship only takes the statute, my lord, only one motion, that it will be taken one after another. That notice is correct, my lord.
Hmm?
Absolutely in conformity with the law. The motion, requisition notice, my lord, the motion that is reflected in Form 1F. It is not says it
No.
motions, only
What
motion.
is your answer to this particular judgment? Montu Sarkar, একবার দেখাও তো এটা। This is not been clarified by you. This is an observation of the court which records the irregularities that separate removal meetings. This notice has to be given.
Your lordship kindly will not interpret the law in terms of my submission, and will not also of the fact, will not that the no confidence motion that has not been challenged before your lordship. The no confidence motion which has been will not
No. We are
taken on
going to
record by
different
CBC
aspects.
that has lost its force.
That's why I asked you the 15 days is not over.
Yes.
So the notice be set as a notice of removal. You give a separate notice of removal and take up the agenda one after the other. Or you interpret this what has been observed in Montu Sarkar, because that records the irregularity wherein three. কি বলো? Petitioner submits that by way of a single motion, single notice of meeting on motion for removal under Form 1F, the notice has been issued under Rule 17(6)(c), 18(6)(c) and 22(4)(c) of the West Bengal Panchayat Constitutional Rule 1975. He indicates that there has to be separate form of notice of meeting on motion for removal of members. Hence, the notice of meeting on motion for removal dated 20th February 2025 is bad in law. In support of his contention, he relies on the decision of this court passed in Montu Sarkar and others versus State of West Bengal others reporting WPA 4367 of 2023. Mr. Shantanu Kumar Mitro, learned senior government advocate, submits that the Rule 22 F of the West Bengal Panchayat Constitution Rule 1975 provides that the motion to remove more than one member or sanchalak of one upasamiti or more than one upasamiti, the motion shall be taken up for consideration one after the other in the same order as mentioned in subsection 2 of 32 capital A. Therefore, the notice of motion issued by the block development officer has been issued in accordance with law. He further submits that the requisition of no confidence motion dated 21st November 2024, which is also challenged in the present writ petition, has lost its force. There is suppression of facts by the petitioners regarding a subsequent requisition made on 22nd February 2025. On such score only, the writ petition is liable to be dismissed. It is a fact that the requisition dated 21st November 2024 has lost its force since as per Rule 22D of the West Bengal Panchayat Constitution Rules 1975, the block development officer is to convene the meeting on a working day which shall not be later than 15 days from the date of receipt of motion by the authority concerned. He further indicates that on 22nd February 2025, a separate requisition has been made on the basis of which the notice of meeting has been issued by the block development officer on 28th February 2025. It is not in dispute that the subsequent requisition has not been mentioned in the writ petition. Be that as it may, the notice for removal, notice of meeting on motion for removal of members is challenged in the present writ petition. By the said notice, 9 of the these are all sanchalaks. They are all sanchalaks.
No, 4 Sanchalaks, 5 members.
4 Sanchalaks and 5 members of the
respective Uposam.
respective Uposomiti has been proposed for taking a decision for their removal. This court in Montu Sarkar Supra in a similar situation has taken note of a irregularity that separate meetings for removal of Sanchalaks of different Uposomitis ought to be notified and separate notices should have been prescribed by the authority with separate timings of the meetings. And the notice of the meeting was set aside. Bearing in mind the aforesaid proposition, since the notice has not been issued separately to the persons, to the members and the Sanchalaks who have been proposed to be removed, the form of notice of meeting on motion for removal issued by the prescribed authority and block development officer dated 28th February 2025 is set aside. The block development officer is, since it is informed that the period of 15 days as envisaged under Rule 22 force D has not elapsed as yet. Hence, prescribed authority block development officer is directed to issue trace form of notice of meeting on motion for removal of members under Form 1F separately for holding separate meetings in accordance with law. With the aforesaid observation, writ petition stands dismissed. Yeah. Uh, ও এটাও আছে ওটার মধ্যে
দিয়ে দিন।
182 টা বার let it be there. Mr. Mitra, is it part of your brief? Is it?
Item number 182.
I am for the petition.
Hmm. Biplav. Yes.
Their writ petition, the private respondent filed by the
No
private
urgency.
respondent, was there a direction that the authority, that is Panchayat authority, will consider the representation filed by the respondent number 7. My lord, that order is at page 72. And their writ petition filed by the respondent number 8 was disposed of by directing the Panchayat authority to consider whether the construction is illegal or not. Her representative is required to be considered. The authority has issued notice, taken a decision decision is at page, my lord, last page, page 96. When I filed the petition, my lord, I challenge this notice, this decision. Last page.
Yes.
This is to inform you that the applicant of Mascot, resident of such and such, has not come with clear and did not distort the correct fact. And the documents which have been submitted to us is contrary to each other. Accordingly, the sanction plan has been
Cancel.
cancelled. My lord, I challenge this decision, my lord, in the instant writ petition. My lord, during pendency of the writ petition, my lord, certain subsequent facts have come. Notice was issued, my lord, for self demolition. And subsequently, my lord, another notice has been issued asking me, intimating that tomorrow the construction will be demolished. My lord, I have affirmed two supplementary affidavits. I mean, this is two supplementary. The second supplementary affidavit, my lord, kindly take it up. I annexed both the affirmed on 13. Kindly take up back the supplementary affidavit. Where, my lord, I have annexed both the notice. First notice was issued, my lord, on 24th of February 2025, page 4. My lord, self demolition notice. I was directed to take a step for demolition within a week. Next page, my lord, on 10th of March, the authorities have issued, my lord, notice intimating that the construction will be demolished on 18th of March at 12 o'clock. My lord, both notice I have brought to this notice, I have record, my lord, by supplementary. My respectful submission is so far this two notice, my lord, Panchayat authority has no, the Pradhan has no authority according to section 23(5). He has to refer the matter to the, my lord, subdivisional officer, and he will take decision after giving me hearing. But so far the first decision, 30th October 2024, since it is the, my lord, the impugned in the writ petition, my respectful submission is this, my lord, the according to section 23(5), my lord, the Panchayat has not at all authority to cancel the sanction plan, because my lord, section 23(5) says, where any new structure
Yes.
where any new structure or new building or any addition to any structure or building is being or has been erected or made, as the case may be, in contravention to the provisions of subsection 1, the permission granting authority shall refer the matter to the subdivisional officer concerned, who, after giving the owner of such building an opportunity of being heard, make an order directing the demolition. Therefore, my lord, this provision says, my lord, the sanction plan granting authority, the permission granting authority will refer the matter to the subdivisional officer for demolition. Not for demolition, the authority will take the decision for demolition. When this allegation will come, there is, it is, my lord, in no provision there is that the Panchayat Pradhan will take or adjudicate whether the
Then explains yourself for it.
construction is legal or illegal.
Who-
No, nothing. No provision is there.
Not affidavit. Huh.
But what I my respective subdivision, my lord, kindly
Thanks for
direct the
making
Panchayat Pradhan to refer the entire matter to the subdivisional officer. I have nothing.
has admitted that the application sanction will make granted sanction of an investment. The plan has not been guaranteed report.
And my lord, my another submission is, my lord, this order cancelling my sanction plan is my lord unreasoned order, non-speaking order. My lord, I am relying upon a decision.
No, what about your submissions with regard to the orders passed in WP CRC 91 of 20?
My lord, the notice was issued a different person, different place. My lord, if your lordships kindly see the address, address is not the my lord. My lord, kindly see I have annexed the I have annexed the petition. My lord, I am saying
You are there in the
my lord,
in
kindly
contempt
see-
application.
My lord,
In the contempt petition, there has been orders passed
Yes,
regarding
yes.
your building plan.
my lord, all are ex party. In contempt application, I am not a party. But so far, writ petition, I was a party. But my lord, kindly see the addresses. Kindly see the addresses. Not the address of the suit property.
What is the plot number? 5356.
My lord, kindly come to page 58. It is the cause title of the earlier writ petition. It starts at my lord page 56. Kindly come to page 58.
Yes.
Page 58, my lord Biplab Noskar, respondent number 8, and Pushpa Noskar, respondent number 9. Number 8 and 9 both residing under care of Tarapodo Mondol at Mikari Ghata, Katpol.
Hmm.
Well, this is not the address of the suit property.
This is your address.
It is not my address. The notice of the writ petition was sent to a different part, a different place.
Different.
Therefore, I have no say. I could not contest the writ petition.
Okay. No, this is not the correct.
Kindly see my address in the writ petition, the instant writ petition. It is my lord, Matla, 4 number Bajar, 7.
Where is the earlier order passed in the writ petition? Earlier order?
Earlier order is at page 72. Affidavit of service filed in today court today is taken on record. They have sent in a different place. Notice was served. That was shown to a produce before the court.
But then after passing of this order, when it came to your knowledge, this had
But when the Panchayat Pradhan Malad issued notice, asked me to participate in the hearing, Malad, I participated in the hearing.
but you have not challenged the order.
File any appeal because my time period the
No,
period was-
on the ground of non-service of notice, since you were not heard, you could have approached the court.
Since the period was my lord over, I had to file the appeal with my lord section 5 application.
That
without
could have
taking
been.
that because my lord, since the order is only for consideration of the representation, I accepted that. All right.
Then that order stands.
Yes,
Now
yes.
you cannot say that the service was yes.
Consideration of representation, I have nothing to say. But my lord, so far after consideration by whom? Must be by the appropriate authority. My lord,
This one 5 and 6 were directed to consider the report.
Consider
Who
the-
was the 5 and 6?
My lord, the 5 and 6 are Pradhan and Panchayat. My lord, they are to my lord, consider the act that whether they have the authority to pass the order cancelling the sanction plan. If they had not, therefore, in that event, my lord, their order will be non-est. The order will be non-est if they had no authority to pass such order.
What was the representation made by the petitioner?
My lord, please at page.
Not your client.
There. I have annexed it, my lord. Kindly come to page 55. No.
If your lordship will kindly come page 23 of the writ petition. This is the vested land. Yes,
the
prior to
petition.
that, my lord, Justice Sinha's order was that.
Well, that will be considered by the subdivisional
Yes,
officer.
yes, yes, yes. Now,
Whether I have right.
page,
My lord, the
page
my lord, the
23.
private
This is the
respondent has
patta,
filed.
there are some conditions.
Private respondent
Kindly
filed.
see, my lord, the material condition is page 6.
I have annexed. I have explained that subsequently it has been extended.
And the
And
Pradhan
sir-
has no authority to grant sanction plan, and he has granting sanction plan, he is cancelling. He has no authority.
Therefore,
Because,
let it be before the FTO.
my lord, the উক্ত ভূমিতে ছিটাবেড়া ব্যতীত কালেক্টর সাহেবের বিনা অনুমতিতে অপর কোন প্রকার স্থায়ী
Page 23, but I have annexed that.
গৃহ নির্মাণ করতে পারিবেন না।
No, he has constructed.
He has constructed. And secondly, my lord, without permission
This
from
is
the
the part-
collector, without permission from the collector, the patta land cannot be transferred. It is the, my lord, patta has been given to someone and that has been transferred to my learned friend's client.
How?
It cannot be, but it has been done.
My lord, it was renewed subsequently. This is my pleading. I have stated in the report.
May be renewed,
My
but
lord, that
terms
will be
and
decided by the subdivisional officer.
But one thing, my lord, it is the fact that, my lord, the
Taken
relating
application.
to the demolition,
Hmm.
the Pradhan has
Well,
no power, the
on
subdivisional
whatever
officer
name
is
or
the
manner,
authority to demolish the construction. It is, my lord, under the law, section 21, section 23(5), the subdivisional officer is the competent authority to demolish the construction.
Let him consider the entire matter.
the continuous shall refer the matter.
And my lord, the respondent number 8, my lord, who filed the writ petition earlier,
When
but he
executed,
filed the suit for partition on the same plot of
receive
land.
an intimation in this regard.
My lord, your client filed that.
That is also total misconception. No
That
suit
suit
can
is
be,
pending.
that suit is also
No,
not
that was reported
maintained.
by Justice Sinha, my lord, in.
That
So
suit is
there also no
pending.
permission.
They filed the suit for partition.
Suit is also not
Therefore,
maintained.
One hand, they are saying that we have right.
Hmm.
Both they are brother and sister. My lord, the petitioner before your lordship and the respondent number 8 are the brother and sister.
I will ask people.
When may I something, my lord?
Yes.
One of the in the instant petition, my lord, kindly come to page 96. The last document, the order of the Pradhan, my lord, the challenge. Well, kindly come, my lord, this is the subject, compliance of the order dated 31st August 2022. Well, 31st August 22 not be challenged by my learned friend. That one attended finally. Now kindly come to 31st August 2022 order, well, page 72. Page 72, well, page 73, the fifth paragraph. After the direction for considering the representation, that was the specific direction of this honorable court. The aforesaid respondents have taken into consideration the specific stand of the petitioner that a plan should not be sanctioned in favor of a private response party in respect of a land which is recorded in favor of the state of West Bengal. So, my lord, since that was not one of the considered, I filed a contempt application. In the contempt application, the one of the Pradhan appeared and one of the submitted a compliance report and says, well, by misconception, I granted this plan, but in henceforth, I have processed for granting sanction plan. Now subsequently, one of this order was passed since the land belongs to the state government. Now one of the plan which was granted in favor of the private respondent has cancelled. Now the last order, Justice Sinha passed an order. Since the order, the plan has been cancelled. So one of the construction which has already been done, that is illegal. So take steps for demolition of undo the wrong. That was the last one. Now one of the
In the contempt
contempt
application.
application.
Yes.
Now on the contempt application, after the plan was cancelled by the Pradhan, the honorable court in a contempt proceeding says, so undo the wrong, so demolish that. So in compliance of the honorable court's order, the demolition notice was passed, self demolition, then the demolition by the Panchayat authority. Now, my respectful submission regarding this, until unless that order has been challenged, so consequential all orders is still the stand. That is not that cannot be the my lord cannot be the set aside in this proceeding. And apart from that,
Hmm.
kindly comes to me, what is his stand? His stand is the land is he by registered deed of March 1983. He got this property. Now, the deed has been annexed. All of the stamp paper of the deed is in the month of May. And he is claiming the deed of all of the subsequent, maybe one of the manufacturer doubtful. Why, my lord, I am submitting this before the authority concerned. That is stamp paper is that. এই স্ট্যাম্প পেপারটা যেটা ভেন্ডার স্ট্যাম্প পেপার সেইখানে লেখা আছে 5-5-30 বলো কাই আর এটা থাকবে তুমি কেন page 27 and now by the council on the earlier discussion I have annexed on here the petitioner before my lord also filed an application for granting pata in respect of the fraud in question. Now I am putting this question myself. If he is claiming his title through his deed, why my lord he filed it again? That I have annexed in my petition. That is petition annexation not in all of that. This is one of the application filed by Biplov.
What is the last order passed in the contempt?
Matter is directed to appear on 20th of this month. Directed the
Pradhan cannot demolish, my lord.
But then there is an order of the court. Why this court will interfere with this?
In that contempt application, I have filed an application for addition of party since I
Then
have
you
not
get
been
yourself
notified.
impleaded as a party, withdraw this writ petition and agitate your point before that court.
Tomorrow they will demolish. Tomorrow they will.
No
demolish.
order in
Kindly
this
consider
prosecution.
contempt
No.
application. My lord, kindly consider contempt application.
Mr. Mahata, you should have pressed for that application before the court and agitated your point. Since the court is session of a matter, whether it is
Application, my
no,
lord,
if there is a order, there is a order upon the Pradhan, whether it is in accordance with law, whether the law does.
my lord, kindly see that.
I have seen 23.5.
Last
Now,
order is
this
first in the
aspect should be decided by the court before which it is pending.
No, my lord, kindly consider.
No, I will not get into it. No,
My lord, kindly-
no, Mr. Mahata. No.
my lord, kindly see this. What the order passed by.
What is the application? What is the application number? You addition of party?
My lord, the contempt application.
Yes.
Well, I'm giving that. Well, so far the order passed by the in contempt application, my lord, Pradhan is directed to take necessary consequent step in the matter of, there is no direction for demolition. Well, kindly see this. My lord,
There
this
are
is the
orders been passed and you have also filed an application for getting yourself impleaded in the proceedings.
contempt
So appear,
application.
yes, you appear before that court.
20th is the
No,
date
no,
for
this will be interfering with the order. No,
my lord.
if you follow the orders passed by the court has also given a direction upon the Pradhan to ascertain the plot number. If it is revealed that the plan was sanctioned over a plot recorded in favor of the government, then explanation shall be forwarded as to how the plan has been sanctioned in favor. So there is a consequence of the orders. No.
My lord, kindly see the last order. Kindly see, this is the order passed, last order, my lord, passed in the contempt. There is no whisper, my lord, regarding demolition. Specific
This
order
is
is not
construction
there.
pursuant to sanction illegal one and liable to be. So consequential steps has to be.
The authority, the Panchayat has to follow the 23(5). He has to refer before the SDO. He has to refer the matter to the SDO.
Oh,
There is no
could have been-
direction upon the Pradhan to demolish.
I cannot clarify what my lord has stated regarding consequential steps to be taken by the Pradhan. This court cannot clarify that. Since you have filed an application for addition of party, you get yourself clarified by the court before which has passed this order.
20th, my lord, kindly grant order of stay.
No.
Otherwise, my lord, tomorrow they will demolish, everything will go. My lord, kindly consider.
No. In these proceedings, no. Ashun.
My lord, kindly visualize the. There is
I have visualized.
contempt application, my lord, there is no order for demolition. Consequential must not, my lord, beyond the statute.
No, I will not.
My lord, the
Supplementary
the Pradhan-
affidavit of service.
my lord, the
So
Pradhan,
Mata, I have heard you.
according
Give
to
this affidavit of service.
affidavit of service. Yes, my lord.
Affidavit of service filed on behalf of the petitioner is taken on record.
Sir, my lord, kindly clarify this, my lord. Kindly clarify.
I
this.
cannot.
According to the order passed in the contempt
No.
application. My lord, kindly
I
clarify.
cannot.
My lord, the Pradhan has to.
Mr. Mahata, you could have anticipated this, that this question will fall from the bench. Since there is a proceedings, you say that you have filed an addition. Why you have not pursued before that court? Why should I clarify the order passed by the other bench?
No, my lord.
What should be consequential steps? Let it, since you have filed an application, you can move that. No, I am not going to clarify anything that has been stated, my lord.
Basis, my lord, because of the
No.
issuance of the last notice. My lord, that last notice has been issued subsequently. My lord, kindly visualize. The Pradhan has no authority to issue such notice.
I do it, but this order cannot be. Supplementary affidavit filed by the petitioner, affidavits, দুটো আছে, filed by the petitioner is also taken on record. This writ petition has been filed challenging the for quashing and setting aside of the letter under memo number Matla Roman 1/1006/2024 dated 30th October 2024. Of respondent number 6, Pradhan Matla 1 Gram Panchayat, cancelling the sanctioned building plan of the petitioner. Mr. Robindranath Mahata, learned advocate appearing for the petitioner, submits that the respondent number 6, Pradhan Matla 1 Gram Panchayat, is not the appropriate authority to cancel a building plan sanctioned in favor of the petition. As per section 23 subsection 5 of the West Bengal Panchayat Act 1973, hereinafter referred to as Act of 1973, he submits that the statute requires the Pradhan to refer the matter to the subdivisional officer, who shall thereafter decide the issues in accordance with law. Respondent number 6, Pradhan, has not followed such recourse as enshrined in the Act of 1973. As such, the order passed by the Pradhan cancelling the sanctioned building plan is illegal and should be set aside. He further submits that already demolition notice has been issued by respondent number 6, Pradhan, which is also not in consonance with section 23(5) of the Act of 1973. Mr. Lolit Mohan Mahata, learned additional government pleader, submits that the construction has been made over a plot of land which is a wasted land, against which patta has been issued in favor of one of the parties and not the petitioners. Grandmother of the petitioner. Patta has been issued in favor of grandmother of the petitioner. And therefore, the there ought not to have been issuance of any building sanction plan in favor of the petitioner. Any sanctioning of building plan in favor of the petitioner, since the land is a vested one.
And without the permission of the collector, no transfer also can be made.
The transfer has been made, transfer of patta has been made without the permission of the collector. Para. Mr. So-and-so learned advocate appearing for the private respondents submits that the building plan has been cancelled by respond number 6 in compliance to the order passed by this court in WPA 9206 of 2022. The construction has been undertaken on a government land. Since the demolition has not yet been made, a contempt petition has been filed by his client, respond number 8 and 9, being WPCRC 91 of 2024, within bracket, in WPA 9206 of 2020. Only 8. ওটা 8, 9 নয় 8 হবে। Therefore, the action taken by the respond number 6 Pradhan is in compliance to the orders passed by this court in WPA, in the writ petition, previous writ petition, as well as in the contempt petition. Mr. Mahata, learned advocate for the petitioner, informs the court that his client has filed application in the contempt proceedings for addition of parties, being
Can 1 of 2025.
Can 1 of 2025. This you have handed over. He also indicates that the court has given direction to the Pradhan to take consequential steps and not for demolition. In the earlier writ petition, being WPA 9206 of 2022, filed by respondent number 8 Ivan Oshkor alias Mukherjee, following direction was issued. এখান থেকে রেসপন্ড নাম্বার পেজ নেম লাগিয়ে দিই, এটা ট্যাগ দিয়ে দিন এখান থেকে, এইখান থেকে দেখুন, এই অবধি দাগ দিন। The order impugned paragraph records that the order impugned for cancellation of the plan records that such order has been passed in compliance of the order of this court in WPA 9206 of 2022. Para. Orders passed in the contempt proceedings being WPCRC 91 of 2024 has been placed before this court. On 20th June 2024, order was passed upon the Pradhan to ascertain the plot number over which the plan was sanctioned. এইখান থেকে এটা কোড করে দিন এই 2 para subsequent thereto subsequent thereto on 12 September 2024, following observations were made. এই রাখ দিলাম এখান থেকে প্রধান could have been granted, could not have granted the sanction. এটা থাক দাগ দিয়ে আর ট্যাগ লাগিয়ে thereafter on 30th January 2025, the Honorable Court observed that the Honorable Court has taken into consideration that the Pradhan has cancelled the sanction plan which was granted in favor of the private respondent. 2-3 কোড করে দিন তো 2-3-4 from the aforesaid, it manifests that the issues raised in the writ petition is very much live before the Honorable Court taking up the contempt application. It has been informed by the learned advocate for the petitioner that they have already filed an application for addition of parties in the contempt proceedings. Such being the position, the issues raised in the writ petition cannot be decided, and accordingly the writ petition is disposed of without passing any order. Or connected applications even
Says that without passing any order.
or else I have to dismiss it.
I shall not go before the contempt proceeding. I shall not go before the appellate authority.
Then it is dismissed.
But dismissed, I am kindly let the order be uploaded by course of day so that I can
The writ petition dismissed.
dismiss.
I do not find any merit in the writ petition. Accordingly, the same stands dismissed.
Extreme indulgence, Lord, I'll be praying, my Lord. Item number 5, my Lord, your Lordship has been pleased to dispose of, my Lord. My Lord, I have not been properly instructed. Now the prescribed authority says that separate notices have been issued. So, my Lord,
Ask Mr. Rabiul Islam to come.
kindly takes up at 3 p.m. I will bring all the documents. Kindly takes up. I will give him a notice. My Lord,
You have got the hard copy of that.
I will collect it. I will bring him. Kindly takes it at 3 p.m.
দেখো কে ডিকটেশন নিয়েছিল ওটা 5 এর আইটেমটা যে ডিকটেশন নিয়েছিল দুটোর সময় থাকতে বল give a notice Lordship Mr.
Your Lordship will be taking at 3 p.m. I will bring all the blood documents.
not 3 2 p.m.
Lordship.
2:15 এ রেখে দাও
2:15.
I will try to. I will try to.
Item number 6.
Time for the petition. Time for the private respondent. Time for the respondent number 23.
আরে কি করেছো আজকে কি সারাদিন মোশন
On the previous
তিনটের
occasion,
সময়
the private respondent.
No such permission is required for erecting a boundary wall. Okay. Yes.
But on the previous occasion, my lord, the private respondents placed a judgment by Honorable Justice Vishwanath Shamadar and Shankaracharya. If my lord sees that judgment, 2016 4 CHN, page 709. Lord, the dispute was regards to the boundary wall. It says, my lord, takes up that order. I
এটা গেল
believe
কোথায়?
your lordship's record.
Yes.
Lord, may I just read out to your lordship? Lord, the subpara boundary wall at the very first page. So it says that the court discussed the provisions of section 23 of the West Bengal Panchayat Act 1973, which deals with the control of building operations within the jurisdiction of Gram Panchayat. It's highlighted that no construction can take place without the previous written permission of the concerned Gram Panchayat. The court also referred to Rule 19 of the West Bengal Panchayat Gram Panchayat Administration Rules 2004, which exempts certain structures from requiring permission, such as thatch structures, tin sheds, or tile sheds without brick walls, covering an area of not exceeding 18 square meters. Now, my lord, I pause here for a moment. I will show your lordship few pictures of the construction which has been made. And my lord, I'll come to the representation which was made by me after that.
Indian serving sets of recurring permits such as cash, tin sheet or tile sheet.
But apart from the issue,
Baba, this is
the boundary wall matter.
But then boundary wall.
The allegation is boundary wall I have raised. I have shown, my lord, that
Now,
for
my
boundary
lord-
wall for a residential premises, I do not.
very
need
well,
that
my lord.
section.
Now, my lord, comes to my representation.
What is that rule?
That rule is, my lord, rule 19.3. 19 sub rule 3.
Eight. Well, Gram Panchayat.
The West Bengal Panchayat Rules 2004, Gram Panchayat Administration Rules 2004. Sir, may I hand over?
আচ্ছা এটা দেখে দিতে বলুন
But the rule is 19 exemption and sub rule 3 I am relying on.
এটা কি নতুন বই দিয়েছে 19.3. No permission of Gram Panchayat are necessary for erection of any thatch structure, tin set, tile set
Yes,
without brick wall.
but without brick wall. And my lord sees the pictures as well.
My lord, this is the extended provision, my lord, deals with various aspects. Unless it is made of brick or cement and the bounded area is not kept as vacant land, but it is used or likely to be used as stackyard or for any commercial or institutional purpose, either on open space or by erecting temporary shed. Now, my lord, kindly not take me amiss. The statute is bit ambiguous, my lord.
Permission of a shelter is a erection of one
Division bench has clarified this
unless it is
statute
made of
in the
brick or
judgment.
cement and bounded.
But my premises is residential.
Now, my lord, kindly takes up the
Boundary is not
judgment for
kept as
once.
vacant land, but is used like a horse in a commercial. But the residential area is not included in 19.3.
My lord,
Yes.
that what is said, je, the commercial or institutional purpose only the sanction is needed. But except for these two purposes, sanction is not needed. My lord, kindly come to the judgment,
Made of brick
paragraph
or
number 7.
cement and boundary is not kept as vacant. There are two precise grounds in which no permission will be required. One is the boundary wall should not be made of brick or cement, and the bounded area should not be vacant, but it is used and likely to be used as stackyard or institutional commercial purpose.
If commercial or institutional, sanction is required. But if not, not required.
No, my lord.
No, my lord, kindly come to the
My
judgment.
lord, kindly seize the provision for once.
Paragraph
Shall not be necessary for erection of a boundary unless it is made of brick or cement. Yours is brick or cement.
Yes.
Yes.
Yours is not vacant. It is residence,
My lord,
not
my
kept as vacant.
my averment is if it is residential, it is immaterial brick or cement, or it is immaterial, it is made of whatsoever. If residential, not needed. My lord, the division bench of this honorable court has clarified because, my lord, as per my understanding, the statute is bit ambiguous. Kindly come to paragraph 7, my lord. Of the judgment, the clarification is there. May I read, my lord?
Necessary.
Fair perusal of sub-rule 3 of 19 as quoted above reveals that no permission from a Gram Panchayat is necessary for erection of a boundary wall unless it is made of brick or cement and the bounded area is not kept as vacant land, but it is likely to be used as a stackyard or for commercial or institutional purpose, either on open space or by erecting commercial a temporary state. This is the statute. Now, my lord, in other words, if a boundary wall is erected out of brick or cement and within the bounded area, the land is vacant or used for non-commercial or non-institutional purpose, there is no requirement for permission from the concerned Gram Panchayat. Now, my lord, mine is non-commercial, also non-institutional.
My lord, kindly
And my
comes
lord,
to
kindly
section 23.
also consider the paragraph 8. The clear language of the statute is self-explanatory in nature. The factual narration preceding the decision rendered by the Pradhan of the GP, which was the subject matter of challenge before the writ court, does not disclose construction of a boundary wall for commercial or institutional purpose for which permission was required to be obtained in terms of such and such rule from the concerned GP. Rather, the factual narration preceding the decision rendered by the Pradhan of the concerned GP clearly reveals that the said wall was being constructed around the perimeter of a residential house of the appellants. As such, there was no unauthorized construction of a boundary wall which could have
My lord,
led to an order passed
This
by the
is
Pradhan of
regards
the
to a
GP.
boundary wall. And my lord, this construction
Same
is
case,
not
my
a boundary wall, my lord. It's a pakka construction. If my lord sees
No,
the
my lord.
pictures for once.
For construction of the building, I have objection. My lord, kindly come to page 25. The petitioner himself gave the representation where he has only says boundary wall.
My lord,
And the
after that,
next
my lord,
page,
a
when
subsequent
the
representation was preferred. My
subsequent
lord, अरे भाई बोलते हैं.
Because my lord, kindly see page 24 is the complaint, the rather representation saying by the client. Now, page 25. Over there, my lord, she only alleged that কোনো ছাড় না রাখিয়া দিলে.
And my lord, Prachir
Then this part was developed in the representation sent by the learned advocate of the
Her, him, Jagannath.
that
will come page 20.
My lord, the representation is twofold. If my lord sees the representation for once, which is at
Kindly take the last 3-4. He stated one ground floor building with terrace was the northeastern portion of the plot number 12, which is adjacent to the plot number 12, which is the Mondir, is most illegal and unauthorized manner with no sanction plan. Now we come into the fact that the entire building.
my lord, the cause of action is continuing.
Time to time, my lord, changes.
No, my lord, absolutely not.
I have is that the issue is regard to encroachment, which needs to be adjudicated in the civil. Here, Pradhan or my lord, the Panchayat is nothing to do over it. This is my.
But I never changed the stance. My lord, kindly sees page number 25 of the writ petition, my lord, where it was made by the petition of the representation. My lord, it alleges about a boundary dispute. After that, my lord, along with that boundary dispute, my lord, the illegal construction was also alleged at page 26 in my representation, which was made by the learned advocate. So, my lord, the subsequent representation is a twofold representation. My lord, an illegal construction cannot be raised in the garb of encroachment, my lord. Even if the issue of encroachment is there, my lord, yes, my lord, even if the issue of encroachment is there, my lord, as regards to the illegal construction, my lord, that has to be demolished. And my lord, it's apparent from the pictures, my lord, that there is a building which is lying there on.
My lord, may I submit one thing regards to the building, my lord? My lord, in the last paragraph of page 26, which is the learned advocate's letter, my lord, it says that I have raised the ground floor building also. My lord, on the last date of hearing, I have produced before my lord my porcha from the year 2007, which clearly shows that Ghor 3,
Lord,
that
that is
ground floor rooms are already there, my lord.
Lord, that is a separate building, my lord.
And no, not separate building. That dag itself, my lord, kindly see the
5759.
yes, my lord. That dag itself, over there are rooms already.
Plot number 5758, they are claiming, the private respondents are claiming 575.
5759 is a Mundir.
Yes, my lord.
But
That belongs to me, my lord.
5758.
yes, they claim
Also,
that
my
their
lord,
property is
5759.
Their
This
property.
is basically a private.
I have given the 5758 porcha, my lord. It is written
as an equivalence, you could have approached this.
Hmm.
But I'll
For the state, do we have?
Nothing to say.
The only thing what I can say, Lord, video and SEO for the.
But I'll rely on a judgment, my lord.
Yes.
But I'll rely on a judgment. But this was passed by my lord, but her ladyship relied on several decisions.
Hmm.
To that extent, my lord.
What is the conclusion?
But I'll tell you, lordship. Lord, an inspection was conducted, my lord. At the conclusion, my lord. Without getting into the private, that's only the unauthorized construction.
Where is it, Porcha?
My lord, I have
দেখো তো এটা কিনা this one
In the middle portion, what? And the flag number 5758.
হুম,
I'm understanding all the.
ঠিক আছে, রাখ। রাখুন, এসে ডিকটেশন। After I come back, I will dictate the order.
Item number 6.
But I, while I'm बोलेंगे state authority, but I was told that he took steps in accordance with law. In terms of the order of the judgment of this honorable court and in terms of the provisions of the statute, he has acted. And this is the lordship would find this is the statement signed by the prescribed authority, and these are the notices, my lord.
At one line. Direction to the prescribed authority to issue separate notice of meetings regarding all the nine.
Because you at that point of time I could not
Change the order is, if not taken, if not already taken, if he has taken, he will act in accordance with the.
Yes.
Your lordship.
Yes, if he has done so, then it will be in accordance with law.
Your lordship, kindly have a look at the below the notices. These are all the notices below.
The same notice is
They
same.
have got separate notice, and some of the below members they are not
Sufficient that.
and they refuse to accept. That is also written.
Anyway, if he has taken steps, he will act in accordance with.
Yes.
Yes, yes. So
Absolutely.
there will not be any bar.
এই নোটিশটা যাচ্ছে আলাদা আলাদা।
Further informs the court that already
The separate notices have been sent. But kindly have a look at my statement of.
This is not the separate notice, my lord.
All the separate notices, my lord, I have with me.
This is the notice.
All the separate notices
Conjointly-
I have with
Lord,
me,
Lord.
not conjoint, all the separate notices. And some of the,
submit that. Submit and block development officer of the concerned block has issued
notices.
for
One of the two modes of service, one by hand service,
এগুলো পরে হবে।
one by postal service.
ঠিক আছে।
And also, my lord, I am submitting
বলতে
the
চাই।
persons who didn't refuse to accept, that has also been with me.
service has been made.
Separately.
Separate-
Yes, that is the word.
Separate notices.
And the full stop. He also has been served through post as well as by hand.
All the members were separate notices. Some of them were refused. That is also with me. And they signed it, refused to accept.
Not already.
Yes, last line will be that.
So because there is no bar of holding the meeting. There is no bar holding.
If you correctly done, it will be no bar.
Notice.
Yes.
Then you act in accordance with law by.
You kindly indicate.
His concept is this: 9
Kindly
persons were separately sent notice.
We are with 20th February notice.
Yes.
Lordship, 22nd February.
That is set aside. He has been given liberty to issue in accordance with law. If he has issued, he will act.
Yes.
The notices, the notices which
Chalan.
has been challenged before your lordship, that has been issued in
And-
accordance with law. That has been
May I
issued in
take your
accordance
lordship,
with law. And my lord, he will act on this, my lord. Lordship, kindly indicate this. my
I
lord.
have indicated.
If the separate notices have been issued, he,
It will be done.
no, if, my lord, for my clear understanding, if the separate notices were issued, then my lord,
Your submission, I have changed the direction,
your lordship.
giving liberty to the prescribed authority to issue notice, if not already issued. If he had issued, he will act in accordance with the notice already issued.
Lordship.
Continuing matter 6.
What are the Last by the petitioner or the advocate's slip.
Not a subsequent representation.
That is not your representation. The fund of justice is made by the petitioner or the advocate.
The advocate for the petition on behalf of the petitioner.
My lord,
For consideration of the advocate's later dated 3rd January 20. The petitioner alleges of illegal and unauthorized construction on the ground floor.
Para 9.
On the ground terrace. Five, seven, five, five, six, Moja, Killing, block with station gate number 090 district Calcutta.
Not 5758 and 5759.
I am the owner of 5758. my lord.
Kindly see the Porcha Miller.
I am the owner of 5758.
Kindly see page 23. Page 23 is my Porcha. Page 23, Milord, where it says that 5758 Milord Vastuland. I am the recorded owner. Okay, Milord, the
In
name is
5758, I also have some property. I have handed over the Porcha, my lord. Many people have properties over there.
Property. On the ground. Building with terrace. And thereafter. The allegation of submit that to private respondents without leaving the requisite science space as typically made construction. Stop. Such fact was brought to the notice of the
WPA number 1631 of 1631 of 2022.
One of 22.
My lord, beg to interrupt, my lord. That name is inadvertently given Prasad Bhattacharya.
Panchayat.
90.
Panchayat. Sequential gift. It's a the students who advocate on this representation of the petition. 1st March 2023 pertains to making of
State is one. Because BPO and SGO are not one. State is.
Also finds place in the advocate's later dated third January. As has been stated in the advocacy. Incorporation permit of permission as regards boundary one. I have xerox of that page. Mein. Here it permit or permission concern ground. It is not in dispute that the boundary wall surrounds the residential house of the private resident. I see civil rights. That is wanted that the respondent number 6 LA will pick up the encroachment that I am representing the six is the private respondent. I am representing the encroachment should be my son. One side is the directed respondent number. Panchayat and Panchayat.
Item number 7.
On the verge of that now, I get stuck over here from about 90. I'm standing.
Due to some illness, advocate and fever.
My lord, college heard also, my lord, last day. Just regarding demolition of the Dover where construction made by the respondent, private respondent number 8. Kindly come to my report, my lord. And where it has been already on page 29, petition has already kindly come to page 29, my lord. On the last page, that's marked, the last paragraph. One where what the officer number next last paragraph, my lord. 29, minus 29, last page of the yes, last paragraph of the first page. তদন্ত কালে চলে উপস্থিত হইয়া দেখা যায় উত্তর 1251 ডোবাটির অবস্থান উত্তর দক্ষিণ লম্বালম্বী সরকারি রাস্তা সংলগ্ন হয়েছিল আর তদন্তকালে জমি দুই আছে কেবলমাত্র 80%, দক্ষিণাংশে প্রায় 2/3 এখনো ডোবা হিসাবে রইয়াছে, মধ্যাংশ অংশটি বহু পুরনো ভরাট লইয়া করা হইয়াছে দেখা যায়। আছে অংশটি পূর্ব রায় দ্বারা করা হইয়াছে বলিয়া সকলে স্বীকার করেন। Come to the last paragraph, my lord, no অনুযায়ী the last line of the first this last paragraph, কোনো পার্শ্ব করা যায় না, মুক্ত মীমাংসা করে প্রাপ্ত সিদ্ধান্ত অনুযায়ী বিবাদীতে অন্যান্য রায়গণ উক্ত ভরাট বা নির্মাণ কার্যকরী স্বীকার করেন। সরকারি বাদী বর্তমানে বাস্তুগৃহগুলি অবস্থান বর্তমানে বাদ বিভাগ উভয় উক্ত বাসগুলি যাতায়াত পশ্চিমে সরকারি রাস্তা হইতে উক্ত নালিশি যাদের মধ্যভাগে ভরাট অংশ রাস্তার ব্যবহার করে সর্বোপরি নালিশি ডোবা দাগ 1251 বেশিরভাগ অংশে বিরাটি বা মাঠছাড়া ভরাট হইয়া দেখা যাচ্ছে। By directly inspector GP number 114. Last petition also I have submitted one report of government of the state of block platform officer Bhagwan Purbo Midnapur. There also on the annexure of this forwarding letter, my lord, this complaint of the issued by revenue inspector Gorbari Bhaganapur was has been alleged, and it is illegal construction unauthorized.
What's on the petition?
Reverse the petition to demolish the unauthorized construction. And already petitioner has already shown that order period 67 and 23 they have filed titles that is partitions along with instruction and identical injunction granted by the contact. That is the order in motion, my lord. In spite of administrative injunction, private respondent 7 and 8 and 9 without taking any hit and any compliance of the orders, they started the illegal unauthorized construction of the over, and that is the demolition. Character of the water body without sanction within. No sanction plan has been issued by the court. Yes, they have already proceeded before Pradhan, but Pradhan.
After the
Pradhan কাছে গেছিল। And that was the time frame.
That's been done.
That has been done. They have already final. They have
I'm saying only for one.
No one. See, I'm coming. I'm falling down from 19. I'm coming down. My matter is so.
26.
What's the instruction is that and my not number. And should subdivision and office contact Purbo Midnapur Mala next 28. And this rate petition is also. Oh, yes, my lord, 28 page, my lord, SDO. 28 is SDO.
My lord, kindly keep it tomorrow.
Arey, wait, tomorrow I'm hearing.
I have also
I'm
difficulty. My senior is not coming today for
Today what we
medical
did
emergency.
on Partha, on the last occasion it was Partha.
My lord, kindly accommodate for 1 day only. Everything.
My lord, and to Pradhan also 1 for 24. And my lord, come to the page 35, my lord, kindly. There is a grave discrepancy, my lord, on page 35, my lord. My lord, come to the paragraph, my lord, first paragraph of the letter, my lord, 184. That is Sri Rahul, under the instructions and on behalf of my client, Sri Rahul Das, son of Sri Gopal Das, who being minor is represented by his natural guardian father, Sri Gopal Das, and filed a title suit number 6723 against Sri Prajapati Beda and 9 others, praying for partition after demarcation. My lord, over here, Sri Rahul Das, son of Sri Gopal Das, being natural guardian representing minor, filed title suit, but writ petition filed by mother over here. And no documents annexed over here. Writ petition to be dismissed in limine. Guardian is father, mother. That we don't know, my lord. No annexure of this natural guardian representing Lakshmi Rahul Das by through his mother Lakshmi Das. And title suit, my lord, on page 35, it is transpired from the letter of which is issued to Pradhan and all. That is the Gopal Das.
Natural guard. There is
No documents annexed. So that we can identify that he is the father, natural guardian of the mind. She is the mother. Over here, title suit filed by father and writ petition by mother. So discrepancy, my lord. In the court of law, my lord, as per civil procedure code, who is representing the minor, represents throughout Supreme Court office, High Court and Supreme. Over here, mother, title suit for civil court contact, there is an indication their father.
Also legal guardian.
Discrepancy, my lord.
Father has filed the title. He has to file.
But no annexure, my lord.
Father is not available at the time filing of.
My lord, annexure should be given, my lord, but not annex.
I'm asking to forget about that.
My lord, it's better to revert back to Panchayat Pradhan for consideration within time frame. By serving upon the parties, by serving notice upon the both the parties, all parties in present, because it's among the co-sharer, and partition suit already filed in the titles discussed in that civil division. So civil court is above grade court, my lord. My lord is well experienced, my lord, and this matter to be referred.
Above the court, not
Civil court always above.
big court.
And this is separate, my lord.
Correct.
Well, they could have applied with 151 in civil court, civil procedure code for this demolition and this sort of and order 39 rule 4 of contempt of court also. 32A, CP court.
None of the representations are being made before the Pradhan.
Pradhan mean minor 33.
33.
Yes, minor. 30, 30. 35, 35, minor 35.
The advocates later.
The advocates later, through advocates later, they have appeared. Represented to the Secretary of Godwari one Gram Panchayat. The intimation later, that injunction already granted by the learned civil court. Senior division person Panchayat. Its status in respect of nature, character, possession of the core and core scheduled properties. Or is it date fixed, my lord, 18/3/23? As I.
Oh, this is 23. We are in 25.
Oh, 20. 25. Got an base. Consideration.
That Pradhan to consider.
Yes.
Granting them legal to file the this.
And need to be disposed of. Red flag.
Affidavit of
My lord, brief.
Where is the affidavit of service?
My lord, brief is not with me, my lord.
Affidavit of service on the last occasion filed.
Yes, my lord. Who is the advocate on record?
Where is he?
He is not coming today, my lord, due to medical emergency.
It doesn't matter when you are not coming to court.
Not
Because
coming to
this
court,
is
no
very
urgency, my lord.
But due to medical ill,
time of mentioning.
Yes.
Not interested.
no, my lord, we are interested. Kindly, no, my lord.
Now I am ready to dispose of this application. Only the affidavit of service is not available. Why you are sitting before the court?
Can you dismiss the writ petition?
My lord, may I pay for only one day's accommodation? My lord, I will file the affidavit of service.
Right now you file the affidavit of service. Get it done and file it.
Yes, my lord. Then, my lord, it is ready, my lord.
For 3 days this is running in the list and the matter is being
My
called.
lord,
and you
kindly
are not ready with
dismiss.
the affidavit
My
of
lord,
service.
kindly dismiss. Again,
For
tomorrow,
what?
then again, I have to run like
No,
this. So I'm calling from the state. You know.
Get the affidavit of service within half an hour and file the
Yes, ma'am.
affidavit of service.
In the course of it.
Yes, ma'am.
Get it done.
Item number 8.
MD Jannatul Firdaus. My lord, MD Jannatul Firdaus. Yes, ma'am.
But I am waiting for the picture. My unauthorized construction made by the respondent number 9 13 without obtaining permission from the concerned Pradhan. Evolution. The petitioner, father of the petitioner, and the grandfather of the respondent number 9 to 13, of the property, that is DAC number 1053 is a co-sharer of the property. And for that reason, for partition, the petitioner filed a partition suit before the learned court. And on that partition suit, the respondent number, they are co-sharer, and total land 12 satok. The father of the petitioner is 6 satak, and they are 6 satak. And for that reason, partition suit has been filed before the learned court below. And on that partition suit, the petitioner got status quo order regarding the nature and character of the land. If your lordship kindly see page 37, the order passed by the title suit. And order 39, rule 1-2 application has also been filed and obtained order of status quo. That is your lordship. Kindly come, page 37.
There is already order of this court.
Yes, after that, there was a violation for that. 151 application has been filed before the court below. My allegation is regarding the construction. The construction made by the respondent number 9 to 13. This is unauthorized one. For violation, for making construction, I file partition suit for making partition mutes and bound before the co-sharer of that property. But regarding the unauthorized construction, this is only jurisdiction by the Panchayat law, and this is the jurisdiction of Pradhan of the concerned Panchayat authority. He is the appropriate jurisdiction. If your lordship kindly see for a moment, the 23, section 23 of 1, that specification has been given: no person shall erect any new construction or new building without any permission from the competent authority. And 23(6) is the power given to the Pradhan, that is, if any unauthorized construction made by the party, then the Pradhan has the jurisdiction to giving inquiry, make an order directing the demolition of the building. They are regarding their construction for violation, non-violation of the civil or court order. I am agitated before the learned civil court. But regarding the construction, which is unauthorized one, that is decided by the only Pradhan in the under the West Bengal Panchayat Act.
Previously, you filed a police inaction.
But police inaction, that is regarding the unauthorized the construction by violating the civil court's order. That is for that reason I filed 151 application before the learned court below. On that 151 application, OC has been directed to take necessary steps to implement the order of the civil court. That is another matter. On that time, construction is almost completed. And for implementation of the order of the civil court, I filed writ application under the heading police inaction. I annex the order copy of the order. If your lordship kindly see page 53. There was on that time already they are completed the construction. Now my prayer before your lordship, the construction which they made, this is unauthorized one, and I specific representation made before the Pradhan, that is page 51 and 55. If your lordship kindly say 151, the order passed by this honorable high court. Page 53. Page 54, the submission made by my learned friend. Learned counsel appearing on behalf of the private respondent denies the allegation and submits as follows. Before the petition, the petitioner has not specified who among the defendants had been making such unauthorized construction. So there is an acceptance that they made unauthorized construction. Who made, that was not, I made not allegation. For that reason, their submission was that among the defendants had been making such unauthorized construction, but the name was not specified for that reason. However, the private respondents denied categorically that they have done any illegal construction, that too in a violation of a civil court's order. Here, my allegation, I am filing the writ application for implementation of the order of the civil court passed by the civil court, as well as in 151 application, police have already granted favor on me to implement the order of passed by the civil court. At that time, they already, by violating the civil courts order, violating 151 application.
Okay.
Construction. And it's the picture also. If you can see for a moment, the
I
picture
understand.
I
Immediate issue demolition of the
this is the construction, such type of construction without any permission from the Pradhan of the court. If my landed friend have permission from the concerned Pradhan, I will be out of court. And regarding violation, I will my lord struggling in the civil court, in the landed civil court. That is regarding violation. But here, my prayer before your lordship regarding the unauthorized construction, as per section 23 of the 123 subsection 1, as well as 23 of subsection 6, that is the power given the Pradhan. If inquiry, at the time of inquiry, it was found that there is no sanction plan, Pradhan has power to demolish the same. This is prayer before your lordship. And the representation, the written complaint which made before the authority concerned, that is page 51. If your lordship kindly see for a moment, the page 51 is my only to the Pradhan regarding the unauthorized construction. Specification has been given in this structure. I am requesting you to take immediate steps for demolishing the construction as early as.
No, what is that page 55 then?
55 is my another written complaint. Subsequently, that was done by the petitioner. That is page 55 to the Pradhan video officer in charge. That this is also regarding unauthorized construction. If your lordship kindly see page 56.
Okay.
That in this regard, I am requesting you to stop the unauthorized construction and demolish the same at an end. And I annexed also the photograph. That is page 50. This is the unauthorized construction. If your lordship kindly say for a moment, page section 23(1), that no person shall erect any new structure or be adjacent to any structure or building having or not more than 1 square meter and height not more than 6.5 meters in area within the jurisdiction of a Gram Panchayat, except with the previous permission in writing from the Gram Panchayat. And if your lordship kindly says section 6, where any new structure or new building or new addition to any structure or building is being or has been erected or made, as the case may be in contravention of the provision of subsection 1, the authority may, after giving the owner of such building an opportunity of being heard, make an order directing the demolition of the building by the owner within such period and will specify the order and the authority may itself take up the demolition and recover the cost thereof from the owner and the authority. And my allegation against the unauthorized construction, not the violation of the civil court's order or implementation of the civil court's order or as well as 151 application before the civil court, because I am struggling there for their acceptable non-cooperation or non-obeying the order passed by the landed civil court. Now my allegation is against their unauthorized construction over the not without any permission. If any sanction plan is there, then my lord, I will be out of court. And Pradhan is the authority to take that.
What is your name? Your name is your client's name.
Is Kumar Malik, Farooq Malik, Malik, Johar Malik, Asta Malik.
They have a plan.
Have a plan. We have a plan. My lord, we have a plan. We have been constructing according to the plan. We have not made any illegal construction, my lord. This one, my lord, what they are trying to do is the petitioners are trying to restrain us from making the construction, my lord. At this point of time, we have completed the construction as per the section plan. My lord, the allegations they are.
When was it sanctioned on 2020?
Yes.
But then this was never submitted before the earlier read code?
But in the earlier report, there was no need to submit. We have already stated and the court has already recorded my submission.
What you have said?
Construction one. And the second one is that we implement the order of the civil code has directly with the court. The earlier petition was filed as a case in action.
Nowhere it was submitted at all that they have seen that plan. Page 53, 54, if your lordship will see for a moment, there was a no whispering about the sanction.
Anyway, this has been sanctioned.
Let my learned friend give us a copy of the sanction plan. Kindly give 1 day accommodation. Then my lord, I come back. Because as per instruction of my client.
This has to be brought on record at the first instance. Let them file an affidavit in opposition annexing the judge. Yes. Hasan, affidavit service. You appear for the state. Madam, you appear for the state. None is appearing for the state. Both of you will appear. Affidavit of service filed on behalf of the petition is taken on record. Miss Swanso, learned advocate for the petitioner, submits that the petitioner and the private respondents are the co-sharers in respect of the plot. In
Para 2, page 4.
In respect of LR dag number 1053, RS dag number 1062, LR Khotiar number 1198, District Howrah. A partition suit was filed by the petitioner, being title suit number 132 of 2023 before the learned civil judge senior division at Howrah. Stop. In the said suit, status quo order was passed by the civil court as regards the nature, character, and possession of the property in question. Since there was violation of such order by the private respondents, an application was taken out under Order 39 Rule 2A.
Order 39 Rule 1, 2 and 151 application for pre-sale. That was
No, violation of the order of injunction, Order 39 Rule 2A was filed. No.
That is 151 application for pre-sale.
Since there was a violation of the order, an order seeking police help under section 151 of the Code of Civil Procedure was filed by the petitioner. A writ petition for police inaction was also filed, being WPA 441 of 2024. Despite such steps being taken, the private respondents have made constructions have made construction over the property in question without any sanctioned building plan. The petitioners made a representation before the Pradhan, which Pradhan was there, no? Pradhan is not there. Before the Pradhan, Kandua Gram Panchayat, respond number 7. On 5th January. 5th January 2024 and 26th April 2024. However, no steps has been taken by the concerned Gram Panchayat till date, hence this writ petition. On the contrary, Mr. Swanso, learned advocate representing private respondent numbers. 9 to 13 submits that the work of construction has been undertaken on the basis of a sanctioned building plan. He seeks to file affidavit in opposition. Let such affidavit in opposition be filed by the private respondents within a period of 2 weeks. Come up, she has to file a reply, you give an advance copy. 2 weeks. Advance copy of the affidavit in opposition be served upon learned advocate for the petitioner. Reply thereto if any be filed within a week thereafter. None appears on behalf of the state. Ms. So-and-so, Usha Chakraborty, who is the other, along with Namtan Union, you give the names who usually appears on behalf of the state respondent is requested to appear in this matter. Let the names of the be regularized by the concerned authority. And you intend to file any report in this? Okay. State is directed to furnish a report on the returnable date. List this matter after 3 weeks under the heading in the form a report. After 3 weeks under the heading returnable motion. It दिए दो.
Already service kept already.
Yes.
Item number 9.
Well, I am for the petitioner.
Lordship, I am for the state lordship. I'm in online mode.
I am a tender of apology, your lordship. My lord, the page 4, my lord, paragraph 3, my lord, the submit that, my lord, measuring about 43 decimal of land. It should be, my lord, 20 decimal of land. This is a matter of illegal construction, my lord.
Page 4, where is 43? 3.
My lord, this should be 20 decimal of land, my lord.
Which document is 20?
Lord,
Where have you stated that it is 20?
my lord,
20 is the document, annexure P1.
Annexure P1. Well,
Okay.
the matter is, well, the private respondent number 9 making illegal and unlawful construction over my land.
Affidavit of service.
Well, this is my illegal and unauthorized construction.
Actually, written in motion আছে? It is শেষ motion. Pradhan has been served.
Pradhan has been served, my lord. Kindly comes to page.
Lordship, I'm for the state lordship. In this regard, we have sought for instruction, but nothing has yet been come,
Yes.
lordship.
Page 28, my lord.
Wait, let's see. 7068.
Petitioner also filed title suit, my lord. What injunction order regarding the subject land, my lord. But the respondent number 9 did not comply anything, my lord. Is making construction over my land, my lord.
The respondent.
9.
What is his name?
Take Isahak.
Go before the civil court. 76969. You have filed application.
Yes,
Lordship, there is a suit pending before the court below, and they have enjoying the status quo order, lordship. That is in page number 19, lordship. P5, annexure P5. It's civil in nature.
Yes, my lord. There is an injunction order. Petitioner filed this title.
You serve affairs upon the private respondent. It is not complete. Or else you come up with an affidavit of service with the track consignment report showing service upon the private respondent. Affidavit of service filed on behalf of the petitioner is taken on record. It is found that service upon the private respondent number 9 is not complete. Petitioner is directed to file press affidavit of service annexing the track consignment report showing delivery. this matter up to 1 week under the heading motion. 1 week.
Lordship, the appearance of the state may be recorded, Lordship.
It is recorded. নিয়ে নাও এখন। কোনটা পাস দিয়েছে কোথায়?
Item number 10. But item 10, my lord, I'm praying for not to remit. Otherwise, the appearing my lord, he left for due to personal difficulty.
Tomorrow. From morning you are waiting.
Item number 11.
এটা কবেকার আছে গো? দাঁড়ানো কাম প্লিজ জাস্ট এটা রেকর্ড করো অর্ডার on the prayer of learned advocate for the petitioner. Release this matter under the motion after 1 week. এক সপ্তাহ পরে দেবেন রেডি করে
And for the petition. Private respondents.
Pradhan has been served. Mr. Mahath is for the state.
Hold on. 692. 692. Yes. Served, my lord.
Affidavit. Page number?
Or
Okay, I find
consignment N692.
4692.
92. That's my lord.
Served. Private respondent is there and state is also there. Yes.
Kindly come to page 21 of my writ petition, that the representation and a complaint before the Pradhan alleging illegal unauthorized construction by the private respondents, and nature is, my lord, cemented brick built boundary wall without obtaining any sanction plan. That too, the land nature is shally. There cannot be any sanction plan in terms of Rule 26 of the Administrative Rules 2004 and Rule 19. There cannot be any cemented boundary wall in violation or without sanction plan. That's my complaint. Now that has been responded by the Panchayat, page 23. It's a beautiful answer. Page 23, dated 15th of July 2024. It says, in response to your letter dated so and so amongst the above mentioned subject, I would like to inform you that according to RTI Act 2005, under section 6, you have to write to know or get any information from GPN. Or I don't know why he's saying all these things. But here is your prayer for demolition of illegal unauthorized brick built boundary wall. In this matter, an inquiry will be done and report will send to their authority to take higher authority to take necessary measure. There is a proverb in Bengali, আমার শ্যালক পড়িয়াছে বেশি বুঝিয়াছে কম.
So he has gone into Right to Information Act.
Though I didn't make any application under Right to Information Act. Now, where the inquiry is?
Who is Rashid Midday?
Rashid Midday is the petitioner before Lordship.
Petitioner?
Yes.
Yes, Mr.
The illegal construction which is question was that is actually a boundary wall of a demarcated property, and it has been constructed since 50 years for the 50. And there is also an order manner. It is, then it has clearly stated that the property is that is point number 8, madam. That is related to the title, the BLRO that is the title. Title. Here we have obtained property was transferred by the said so and so by in our name, and it has been recorded that there has been no irregularity, my lord.
Irregularity in respect of title, my lord. We are. What is my claim? My claim is construction of boundary wall without any sanction plan.
Although there is no trace of proceeding of correction of the RSRO under section 44(2)(a), that means they are not detailed. Unless 44(2) correction, that is not the question here. Here is the only the construction of the boundary wall. Let it be.
The Pradhan has to make inquiry. Pradhan has to, my lord, come to a conclusion, and he has to place it before the SDO, who is the concerned authority. You can't go beyond that.
No permission could have been granted for congestion. For the classical land is regulated solely as per provision. Cemented to ground of the terms of the concern is necessary. It is evident. What is rule 26 of this?
26. Classification of land for construction. If any structure or building is proposed to be erected,
There is no authority to grant cession.
constructed on any land recorded otherwise than as homestead land, the Gram Panchayat shall withhold permission. This is rule 26 of my lord, rule 20 of 2004, West Bengal Gram Panchayat Administration Rules 2004.
Oh,
Kindly, I can assist you.
এটা থেকে থাকার কথা
Or kindly have it. Rule 26.
If any structure building is proposed to be erected or constructed in any homestead. Okay. It change. Okay. Till such period, it will be withheld.
Yes. So my claim is that there is no sanction plan, and if anyone claims that there is sanction plan, that cannot be in terms of this rule 26. So
What is the classification right now? What is the classification?
Shali.
Okay. No.
Let there be a direction upon the Panchayat to make necessary inquiry and conclude the proceeding, and to refer the same before the sub-divisional officer.
Affidavit of service filed on behalf of the petitioner is taken on record. So and so learned advocate appearing for the petitioner submits that the present writ petition has been filed for consideration of the representation of the seeking direction upon respond number 7 and 8. 7 হচ্ছে 7 Chandpur Gram Panchayat, 8 is Pradhan Chandpur Gram Panchayat to take immediate steps with regard to unauthorized, illegal and unauthorized construction of cemented brick built boundary wall at RS plot number 2893 under RS Khatiyan number 2749, measuring 19 decimals. Bishnupur is the Mauja?
Yes, ma'am.
Mauja Bishnupur. Rajarhat, PS Rajarhat, District 24 Parganas North, measuring more or less 19 decimals of land. Mr. So-and-so, learned advocate for the petitioner, submits that the work of cemented brick built boundary wall has been undertaken by the private respondent over the land classified as Sali. Therefore, the Pradhan Therefore, if any permission is granted by the Pradhan, that is hit by the provisions of Rule 26 of the West Bengal Gram Panchayat Administration Rules 2004. Further, as per provisions of Rule 19 of the West Bengal Gram Panchayat Administration Rules 2004, it is necessary to take permission prior to construction of Pakka boundary wall. In respect of homestead land, no? Sir, it is in respect of homestead land.
Homestead.
Okay. He seeks that, he further indicates that the representation of the petitioner has not been dealt with properly by the Pradhan. He seeks that necessary direction be issued upon the respond number 8, Pradhan ki Gram Panchayat. Chandpur Gram Panchayat, to consider and dispose of the representation of the petitioner in accordance with law. Mr. So-and-so, learned advocate appearing for the private respondent, submits that the construction has been undertaken in accordance with law. Mr. Mahata, Lalit Mohan Mahata, learned advocate for the state respondents, also submits that the matter be relegated to respond number 8, Pradhan, to consider and dispose of the representation of the petitioner dated. Date of the representation is
8 July.
8 July 2024. Upon hearing the learned advocates for the respective parties, respond number 8, Pradhan, Chandpur Gram Panchayat, is directed to consider and dispose of the representation of the petitioner dated 8 July 2024 following the with the cause inspection of the property, and such exercise if found, it shall take recourse to section 23. Such exercise shall be taken within a period of 2 months from date of communication of the order. Which point the other. Learned advocate for the petition is directed to communicate this order to respond number 8, Pradhan, Chandpur Gram Panchayat. It is made clear that the court has not gone into the merits of the application. Since affidavits have not been called for, the allegations made in the writ petition deemed to be not admitted. With the aforesaid direction, the writ petition stands disposed of. All connected applications, if any, are deemed.
Great.
Passover matter 7.
Wait.
My father for medical treatment of my father lordship, I was come later.
Where is your affidavit of service?
except one private respondent, he refused to accept this document.
There is no such representation before the Pradhan.
It's 24 lordships. Initially, that subject plot of land lordships is the Doba, that is pond lordships. And initially, illegally filling up these pond lordships for the purpose of construction of house lordship. Then my client made representation, page 24 lordships. Thereafter lordships, in this connection lordships, concern BLR lordships, made an inquiry lordships, page 29 lordships. Last occasion I placed your lordships. In the middle portion lordships, তদন্তকালে উক্ত স্থানে উপস্থিত হইয়া দেখা যায় যে নালিশি 1251 দাগের ডোবাটির অবস্থান উত্তর দক্ষিণ লম্বালম্বি সরকারি রাস্তা সংলগ্ন। উক্ত দাগে হিয়াদ নকশা একটির সঙ্গে যুক্ত করা হইল, যা উপস্থিত ব্যক্তিগণের হইতে প্রাপ্ত হইয়াছিল। তদন্তকালে পরিলক্ষিত হয় যে ডোবাটি 17 to 18% ভরাট হইয়া গিয়াছে। কেবলমাত্র দক্ষিণাংশে প্রায় 2-3 ডেসিমিল এখনো ডোবা হিসাবে রইয়াছে। মধ্যাংশে অংশটি বহু পুরনো ভরাট হইয়াছে বলে মনে হইতেছে এবং উত্তরাংশে অংশটি সদ্য ভরাট করা হইয়াছে। দেখা যায় উত্তরের অংশ বিবাদী ভরাট করিতেছেন। Let's see here, বিবাদী means গোবিন্দ প্রসাদ, respond number 8.
Okay.
Lordships. Hereafter lordships, they started construction. Page 31 lordships, in the middle portion lordships, জোরপূর্বক ভিত খনন করা কালে অধীনা তাদের প্রতিবাদ করলে নিম্ন তপশিল বর্ণিত আসামিগণ অধীনা তার স্বামীকে অকথ্য ভাষা গালাগাল করে।
Revenue inspector. The revenue inspector is under BDO or SDO?
SDO. The report submitted to the SDO lordship.
To
page 28 lordships.
What SDO?
Page 28.
He has submitted the report before the BDO Bhagwanpur.
To the SDO. At the instance of the SDO, inquiry was made, lordships.
Okay. Yes, then?
Then lordships, thereafter they started illegal construction lordships, and lastly lordship, through the learned advocate, made a representation 1/4/2024, page 35 lordships. And paragraph 4 lordships specifically stated, page 36 lordships, paragraph number 4 lordships, in the middle, in spite of imposition of the aforesaid order of in the both the party lordships file a partition suit, and in that partition suit lordships, there is ad interim injunction order was there lordships. But in spite of order of injunction lordships, by violation of the injunction order, they made construction lordships. Lordships, paragraph 4 lordships, in spite of imposition of the aforesaid order of interim injunction concern the co and co scheduled land as mentioned herein below, 2 persons, namely Govinda Prasad Das, this is respond number 8 lordships, and son of Kanai Das of village Bajkul, and such and second lordship, Prajapati Bera, respond number 9 lordship, son of Godadhar Bera, district such and such, have been forcibly cutting the standing trees and have been making attempt to construct the residential house lordship. Lordship, my first submission lordship, regarding illegal filling up of the pond lordship, according to the provision, full 22 lordships. Full 22 lordships of the West Bengal Panchayat, Gram Panchayat administration rule lordships. Restriction on construction over the tank and water body lordship. Twenty-two lordships.
22.
22 lordships. May I read lordships? A Gram Panchayat shall not giving permission to any erection or construction by filling up any tank, pond, otherwise water body, marshland, or abandoned brick field or sand quarry, coal and such and such losses. Then losses kindly surplus two losses, the bottom losses. In case of illegal filling up any tank, pond, or otherwise water body, marshland, and such losses within the Gram Panchayat area, in the water area, the Gram Panchayat shall immediately report the matter to the executive officer of the Gram Panchayat Samiti. The executive officer of the Panchayat Samiti means the BDO. So first instance, regarding the illegal fill up the pond losses, the Gram Panchayat, concerned Gram Panchayat may refer the matter to the concerned executive officer of the Panchayat Samiti losses. Regarding illegal fill up the pond losses. Second thing losses, regarding the illegal construction and losses awareness provision, section 23 of the Control of Building Operations, the West Bengal Panchayat Rule.
Panchayat Act.
Panchayat Act losses. Panchayat Act, section 23 losses. Several judgment losses, losses already observed. Regarding illegal construction, rule provides section 23 losses. Regarding illegal fill up losses, rule 22 losses, the Panchayat authority may refer to the executive officer of the Panchayat Samiti. To the concerned Panchayat authority losses, consider this provision losses and pass this order losses. This is my respect to submission losses. Pradhan. Yes. Pradhan may refer to the executive officer of the Panchayat.
But then the revenue inspector has submitted report and BDO is not informed.
Revenue officer losses.
He has submitted the report.
Report the SDO.
Yes.
SDO.
Is he not informed? BDO is informed of the fact that there is filling up. What steps the BDO has taken after the revenue inspector has submitted the report?
The admittedly nature of the land is global. I have annexed.
What is the steps taken by the BDO after revenue inspector has submitted report stating that there is a filling up of a local pond?
No intimation.
80% of that has been filled up. No, you take instruction regarding the steps taken by the BDO after revenue inspector has submitted its report on the basis of his application. And you submit that report. Not required right now. You keep it with.
That's why I can file the supplementary affidavit regarding the present position of the construction of this.
So let us see first what the BDO has taken steps. Though the rules furnish that the submit rules provides for the Gram Panchayat has to take steps.
Yes.
But in this case, since you have approached the SDO, the revenue officer has submitted a report. That report, what steps he has taken for towards that filling up, that should be looked into. Asu, affidavit of service filed on behalf of petition is taken on record. Anybody representing your Pradhan? Has any steps been taken from the side of the Gram Panchayat? No, you are not informed. You are not informed. Why? You are informed, you are not taking steps. What representations are already, he has made an application before the SDO, which has been relegated to the BDO, then revenue inspector calls an inspection, then says 80% has been filled up. That's why I'm asking you, 80% of a water body has been filled up, you are not informed, you are not taking steps. You file your report. You file your report, she will take instruction from the BDO regarding the steps taken. The petitioner alleges of filling up of water body
Number 1251.
adjacent to dag number 1252. What is the Mauja? Mauja?
Mauja Bajkul, Lordship.
Mauja Bajkul.
Paragraph 3, Lordship, I have mentioned.
And also of unauthorized construction over the water body.
Water body plot number 1251.
Water body টা 1251 হবে। over করে দাও। filling of water body add করো, add দাগ number 1251. With the aforesaid contention, an application was submitted before the SDO Kontai subdivision, Purbo Medinipur. An inquiry was made by the revenue inspector, Gram Panchayat number 1, Bhagavanpur 2. Learned advocate fails to apprise the court regarding the steps
Page 29.
Taken by page 29. Page 29 is a report.
সমষ্টি ভূমি ও ভূমি সংস্কার আধিকারিক, that is BDO.
This is not video. Fails to apprise the court regarding the steps taken by the subdivisional officer after submission of report by the revenue inspector, forwarded by the block land and land reforms officer, Bhagwanpur 2, Purbo Medinipur on 10th August 2023. State respondent is directed to furnish a report disclosing the steps taken by the subdivisional officer Kontai Purbo Medinipur upon submission of report by the revenue inspector Gram Panchayat number 1, Bhagavanpur 2.
Respondent number 6, Lordship, Pradhan Godbari 1, Gram Panchayat. Number 6, Lordship.
Respondent number 6 is also directed to furnish a report in respect of the issues raised in the present writ petition. আচ্ছা, এই reports গুলো বলে দাও within a period of 2 weeks. 3 weeks পরে reply thereto reports with the exception হবে by way of affidavit subtitle. Yes, by way of affidavit exception both exception thereto if any be filed within a week thereafter list this matter after 3 weeks under the heading returnable motion. Returnable motion. একটু সাজিয়ে নেবে এই অ্যাফিডেভিটটা নাও returnable motion.
Item number 366.
Please affidavit of service. Affidavit of service.
Have prepared the service, but it could not be affirmed in the service. Affidavit service could
Not
be
today.
affirmed. The difficulty is that the letter by which we had served, we had filed that original letter with the last affidavit of service. Without that letter,
What letter?
we cannot get it affirmed. That is the difficulty I am being told.
Last time you filed the affidavit? Which letter? This copy of the letter is not with you.
No, this copy of the letter is not with that. The original letter has been annexed.
Then you serve afresh. So and so learned advocate indicates that the letter sent to the addressee has already been filed with the previous affidavit of service. He seeks to serve afresh upon the respondents. Oh, then which respondents he is to serve? Oh, that matter? That digit?
One digit.
What are you doing, sir?
Unfortunate. I am supporting the cause of the petitioner, but she herself did the mistake.
Within a week you can do it? Have a phrase. Let such service be effected upon. Which were the authorities I directed to?
We had served upon the school authorities. The
That
DI
it, yes, effect service upon the added respondent 5, 6, and 7 by registered speed post with acknowledgement due and file affidavit of service on the returnable date. Manager has not been added as a party, but there was a direction to serve upon the bank manager.
we have served. Track report is the manager is already a party.
Branch manager is a party? Achha.
The original branch manager.
Respondent number 3 is the branch manager.
Union of India is respond number?
4.
4. 5, 6 আছে তার আগে 4 add করুন 4.
5, 6, 7.
হ্যাঁ petitioner is directed to serve notice upon the branch manager Punjab National Bank Najat branch district North 24 Parganas intimating the next date of hearing. These additions have been made in the writ petition. Okay. list this matter after a week. Huh? 10 days. List this matter date বলুন তো 10 দিন পরে 28th March.
Item number 367.
Reply.
Women's. This group was formed for the purpose of cooked midday meal in the local schools. My lord. My lord, their group was registered in the National Livelihood Mission project, my lord, and they made several representations to the authority, BDO, Sabhapati, Pradhan, for the purpose of enlistment of their group so that they can get the work of cooking midday meal. And my lord, on the earlier occasion, the writ petitioner moved a writ application, and this Justice Shampa Sarkar directed the petitioner to, my lord, page 31 to make a representation before the authority, and the representation was rejected. My lord, page 31. The petition number 1 is granted liberty to approach the block development officer Kultoli development block, seeking reasons as to why the name of the petition number 1 did not appear in the list published by the concerned block development officer dated April 21st, 2022 as an enlisted self-help group for supply of cooked midday meal under Kultoli development block. Page 32, then petitioner files a representation before the
Did not
concerned
appear
block
in the
development officer. The same shall be disposed of in accordance with law. The reasons as to why the candidature of the petition number 1 was not considered shall be intimated. The petition number 2 by the block development officer concerned, who was also a part of the selection. My lord, they passed an order. Page 34 onwards of the writ petition, my lord. My lord, nature of the case at the top, nature of the case WPA number so and so of 2022, Nivedita Mohila Gram Swarajya Dal and another versus state. My lord, the video started the compliance 21st April 2022. At that time, no representation was filed. 21st April 2022, a committee was formed comprising of 5 members, by memo number so and so dated 25th January.
Why the representation was not fine? Why representation was not fine?
Representation was there are so many representation, but lordship, his lordship.
After passing of the order in the writ petition,
yes,
when did you file your representation?
6th December. My lord, it was representation was submitted on 6th 12 2022. My lord, this is not annexed in my representation. In my writ petition, my lord.
Why?
But it is representation was rejected. Next page, page 35.
You have a copy of the representation?
But it was,
Now, what is annexure P9?
P9 is a letter. This letter was issued. This letter was sent by one Sodosho, Gopalganj Gram Panchayat, a member of the Gopalganj Gram Panchayat. She intimated the district magistrate and sub-divisional officer. Subject, my lord, I am placing this document. Page 36.
Where is the copy of the representation?
My lord, this document was not at that time. It was not available. It was not annexed, my lord.
So how could it be assessed in the particular writ petition? But the crux of the matter is 612 that has been left out. You say that your representation was not considered in accordance with law and you miss out the representation itself.
Was considered and rejected.
Anyway, he will show his ground that on such and such ground. And without that representation, how the
I will supplement.
You do not have the copy right now.
I have the copy.
What is the contents and din? দিয়ে ওটাকে annex করে দেবে। Let it come on record first. No? Mr. Swansulan, advocate. This group has been registered under.
National Livelihood Mission program.
Where is that document?
Yes, ma'am. I have annexed. Page 19 of my writ petition.
Okay.
National Rural Livelihood Mission.
Now, once it is registered in this portal, they are automatically been listed with the local. They have to make an application.
Make an application, and the BDO will enlist the eligible groups
Okay.
for the purpose of preparation of cooked midday meal in the local schools.
Mr. Swansulan, advocate for the petitioner seeks leave to file supplementary affidavit annexing the representation dated 6 December 2022. Leave granted, let such supplementary affidavit be filed within a period of 1 week, annexing the representation dated 6 December 2022. Copy of such supplementary affidavit be served upon the learned advocate representing state respondents. List this matter after 1 week under the heading written motion.
Item number 368. Milord, on behalf of petitioner's advocate, praying adjournment for today.
Twenty-three.
Hello.
You have filed your opposition. Okay.
Petitioner's advocate is not.
Instant writ petition. Correct. Must be passed by regional executive magistrate. And the petition relevant Panchayat. Under the time of sanction of the development plan. What is the challenge in the writ petition? The reasoned order. What was the first writ petition which was filed? Purbo Medinipur return and decide all the issues raised here. That is. $60. Now, what is the ground of their challenge? Principal ground. The wide concrete approach road has been ascertained. No easement rights sanctioned by Renu. Since road pathway under consideration has been used for is 15 years, it is difficult to assume whether the character of land over which the road has now been constructed near the purpose. Engineering plans. Mentioned by all parties concerned and according. What about the ground in the earlier writ petition regarding subsection section 24 subsection 2? Come to page 49 of the writ petition. You have come? Yes. What is your case?
I have some record is there, my lord. There is illegality in sanctioning the my lord plan. They have considered in all respect, my lord, and we approve the plan.
No, you are for the petitioner. Who is for the petitioner? You are for the Jila Parishad. So nobody is appearing for the petitioner. Property petition 7th March, not today. Well,
all these giving opportunity to all concerned. Matter was heard and observing all formalities and it was held from page 60 and the above goal of that and welfare of the submitted documents to observe that the answer was significant was maintaining all documents. And now we are challenging the bringing the report was confirmed by this bench and put on 3rd October 2023. And ultimately, report was completed. We are not saying for more.
এটা 7 তারিখে নট টুডে হয়েছিল না 7th Order. You are filing this report. Was there any direction to file the report? By 17, so it is. A report filed on behalf of respond numbers 3, 4, and 5. In terms of order dated 3rd October 2023 is taken on record. None appears on behalf of the petitioner, nor any accommodation has been sought for. In view of the above, the writ petition stands dismissed for default.
This matter, is appearing. This is a change. Certain ill health emergency situation in the house. Yes.
How is it 23? 2023 is the writ petition. How long this will go on, sir? What, one day? Do you know on 7th March this was made, not today? This was running as 335 item number. You are not there. Now next day the other person will come. He was not there. Why? Whatever you have to submit, you submit. You submit. Then you have no knowledge. The other person, Mr. What is his name? Pappu? Pappu Adhikari, he is not there. Brief is with Mr. Adhikari. You are moving the application.
I'm paying for an accommodation. Only for 1 day.
এদিকে মেনশন করেছো দেখো তো ওই তো বাপ্পু অধিকারী Then why do you mention when the matter is not urgent? What is the matter? The other matters can be taken up. You have mentioned you are not there. When the court is dismissing for default, you appear and seek adjournment. So is it not right for Mr. Odhikari to remain present when the matter is taken up? Why do you mention then? There are so many matters. The people are waiting. Adjourning a matter, wastage of time. This is not. If you are ready with the matter, then mention. Please don't mention. If you are ready with the matter, then mention. Before taking the matter in the list, I ask you whether affidavits have been filed, whether the matter is ready for hearing. Then you mention. Hello. Mr. Suvansu, what is your name? Appearing for the petitioner seeks accommodation. এক সপ্তাহ পরে রেখে দিই। কবে আসছে? After 1 week.
25th. Item number 369.
Let it come up, we'll see. Mention করো।
Kindly come to page 40. On the petitioner being a member of the Gram Panchayat, he raised objection regarding some financial irregularities made in the earlier term. Page 40. Inquiry was conducted, and this is the prima facie report at page 40. This is the report, my lord, by the block development officer Kaliachok 3 to the additional district magistrate Malda. As per inspection under section 205 of the West Bengal Panchayat Act 1973, conducted on 21st of September 2022 by Sri Jibon Kanal Mandol, as well as internal audit conducted on 10th of August 2022 by Ashraful Islam, PAO of Kaliachok 3 block, it revealed that the So-and-so Gram Panchayat authority misappropriated the entire fund of rupees 14,25,852 under 14th Finance Commission for construction of marriage hall on the land of Subodh Pramani. Now they have narrated in which way that has been done. Skip the last next paragraph, then kindly From above facts, it is clear in the Roman 1, the authority tampered and confiscated the comparative statement of contract number so and so generated through e-procurement system of the government of West Bengal. Second, Gram Panchayat paid the above bill without taking prior financial approval of the block development officer, though relaxation in respect of inspection of infrastructure activity by inspection committee was between so and so as per memo dated so and so dated ato. Next 3, as per confiscated document of Gram Panchayat, bill should be paid to Mrs. Rana Construction, but the authority paid the bill amounting rupees 12 lakhs odd to Jit Enterprise Kalinagar, though this agency was not executed the said scheme as per the document of this Gram Panchayat. Next, Gram Panchayat paid more amount of rupees 1,63,000 and odd than tendered amount. Tendered amount is rupees 12,62,000 odd, and the bill amount is 14,25,852 to the contractor. Gram Panchayat authority should recover the said amount from so and so. These are the observation. In view, the last paragraph, in view of the above circumstances, the undersigned is seeking instruction from your end regarding further course of many may be taken against the responsible persons of the said Gram Panchayat for such malpractice in implementing of the scheme, namely construction of marriage hall on the land of Shubodh Pramanik by so and so Gram Panchayat. Now, next page 42. This is the response of the Malad Additional District Magistrate to the BDO. Page 42, my lord. The last page of the petition. Yes, my lord. Annexed P8. It's dated, my lord. 12. The last page, my lord, dated 12th of April 2023.
Yes.
Yes, ma'am. Now, this is written by the additional district magistrate to the block development officer in respect of that particular inquiry report. In connection with the above mentioned subject and reference on the basis of your inquiry report, it can be concluded that a misappropriation of public money was made in this particular case at so-and-so Gram Panchayat under so-and-so block. This is to be treated as a serious offense, especially in the present scenario. You are hereby requested to ask concerned Pradhan of so-and-so Gram Panchayat by name to submit a clarification with why proceedings will not be initiated against him for such malpractice. Ask concerned executive assistant of so-and-so the same thing, and ask all signatories of the resolution. Now, what's happened thereafter? The state authority on the file a report before this court. Now, kindly have a look to that report, my lord. It's a beautiful thing that someone is being alleged for rash driving, except the driver. They have taken actions against all other persons except Pradhan. I don't know why. Why the video is so shy or so sympathetic about the Pradhan. The report is before your lordship. Your lordship will not get a single document to show that even she was asked to submit any clarification or anything like this.
No, this report is brief history of WPA. This starts with
yes.
Who are the persons who have been proceedings has been initiated against the person?
The government employees.
Thou to do?
Here the Indian Model Executive Assistant of Calcutta Panchayat, Ikramul Haq, Secretary, and the Sandeep Anthas, the Nirman Fire. Who are the party to the this is within the domain of the block development officer, my lord. In respect of the Pradhan, my lord, state government has to give a direction for taking action under
Ex-Pradhan. Ex-Pradhan, he is an individual. And he was asked to submit clarification by the additional district magistrate. The video is shy about that. He didn't issue a show cause even. And the amount is 14 lakhs.
At that point of time, he was the Pradhan.
At that point of time, he was the Pradhan. Now he's no more Pradhan. So proceeding should have been against her. And the Malad, specifically, the district magistrate say, asks concerned Pradhan of so and so by name to submit clarification. Even that notice was not issued by the video. Why he wants to hide the Pradhan? They don't want to reach to the root of this corruption. I think they are the party to this corruption.
Any criminal proceedings has been initiated? What is the stage of these departmental proceedings against this?
If I started in my lord in 2025, clearly their focus notice were there. Their focus reply by notification. There are several and my lord, in respect of the my lord, the Pradhan my lord, the affair ought to have been issued. But my lord, now my lord, because the permission previously my lord, he was holding the post. And under section 230 permission was required from the state government to take action against the Pradhan. Now, my lord, he is an individual. How he will take action against the
What's it?
Oh,
I am
wait.
appearing from the erstwhile Pradhan.
Wait. Now, what is the prayer in the writ petition for initiation of proceedings against the Pradhan?
Against all the wrongdoer.
What is
Have
the
to prayer B, my lord. Prayer B at page 12 of my writ petition.
okay? So, what is the explanation of the video regarding not issuing any so-called notice to the erstwhile Pradhan?
Despite of direction of ADM.
I have just now, my lord, I have got the explanation, but I have to take explanation. So this is serious question. Because it is the finding of the block development officer that they are in this.
Now he has inquired where is this
The video himself
which was placed before the additional district magistrate.
Yes. Page 40. Page 40 of my writ petition.
40 and 41. Now,
and every payment in Gram Panchayat that is to be made
through the
signature of the three person. One is executive officer, executive assistant, I believe. Another is Nirman Shoaib.
No,
and
he
third is the
himself.
Pradhan.
In page, your annexure B, he himself says that the Gram Panchayat paid the above bills without prior financial approval from the block development officer. At the time of issuance of so cause, he is left out. Yes, Mr. Sir.
My lord, I am challenging the entire issue, my lord. Entire issue, my lord. My submission in this point, my lord, their basic question in their relief, A, 225 is to made a request to conclude the investigation. If investigation has not yet been completed, then further action is infractious. How this is being made out, I don't know. My lord, my submission. Their allegation is there is one land, there has been a construction, and there is a total fund has been misappropriated. If there is constructions,
They have not told anything about the quality of the construction, who is possessing at this building now, whether that very building is in my own land or someone private land or in the Panchayat land. All these issues are concerned. I'm just submitting one point, my lord, and how this entire issue is distorted. One land that is impugned land, my lord, that was someone in the Panchayat has donated the land to the Panchayat. Then Panchayat came to a decision and took a resolution that there should be a marriage hall. That proposal was sent to the district magistrate. Then district magistrate accorded the permission. Annual action plan was approved, on the basis of which there was the tender committee. That tender committee invited the tender. Then tender committee, after issuing the work order, building construction was done, and further issue of measurement, then process, everything was done. I don't know, my lord, how all these issues are coming. Thus, since, my lord, I am no longer in the post of Pradhan, I have no document in my possession. I have handed over within the section 9A subsection.
Document has been confiscated.
My lord, may I conclude, my lord? My submission, my lord, in this aspect, my lord, let BDO come with a affidavit in opposition, and I may kindly be allowed to deal with the oppositions, my lord. Otherwise, my lord, this is a totally, my lord, I'm just giving one example. This is the document, what has been transferred as the supplementary document. It is a document between client and to his advocate. This is the privileged communication.
Which one?
This is the brief history supplement. My lord, this supplement has been provided from the end of the video to the state advocate. And in the page 2, my lord.
Let me explain this, because my learned friend was not there.
I'm
No, you are not there. You are misleading this court. Kindly come to the order dated 7th of November 2024. There must be a limit of this.
My lord, may I conclude, my lord?
7th November 2024. What my learned friend is showing. This report was placed before this court once. Then somehow the advocate for the state was not present. I was granted liberty to bring this report through a supplementary affidavit. Since that report was handed over to us on the first day of hearing, 7th November 2024. In the meantime, the
my lord, may I kindly continue with my submission?
Available by the state respondents.
My lord, may I kindly continue? Lordship's attention to the page 2, my lord, para 2, my lord, that the writ petition was taken up firstly for hearing on 20 June 24. This is their submission. Report was filed by the state respondent before the honorable court, and a copy of which was also handed over to the
how the bills were being issued?
This is the thing I am just telling, my lord.
Why are you going into the matter of construction? Forget about that. How the bills have been paid to the contractor who has not participated in making construction?
Been under the imprisonment, he is before lordship and
my lord, I am there.
I am not hearing you. You filed your affidavit in opposition.
Yes, my lord.
But
you file that. Whatever be your content.
The inquiry report we file if you not.
My lord,
BDO,
one submission in this.
BDO also, you ask the BDO. Sir, please.
One submission, my lord.
You ask the BDO to file a report in the form of affidavit.
Yes, ma'am.
Everything should be on record in the form of affidavit. Advance copy of that be given to the petitioner. You go through that. If you may want to make any exception to that or reply to the affidavit, let that be also on record.
Explain why they have excluded the Pradhan. In their
It is.
Kindly make it, my lord, make it.
My lord, my one submission, my lord. Since I have handed over entire charge, my lord, I have no access to any document, my lord. I may allow to access to the documents, my lord, so that I can give my reply.
No. Who is this person?
Misappropriated the money collusion with the
So you are not the member of the Panchayat? Was. So you have left, the Pradhan has left.
Your lordship.
Okay. You file your pleadings.
Justice Sarkar used to say, "Upore Bhagavan, niche Pradhan, no one in between." Yes, Justice Sarkar.
This writ petition is filed alleging of misappropriation of public money at Bakrabad Gram Panchayat. Mr. Mohammad Sarwar Jahan, learned advocate for the petitioner, submits that the block development officer filed its inquiry report before the additional district magistrate, Malda, disclosing certain irregularities in dealing with the public money at Bakrabad Gram Panchayat. The additional district magistrate, the Panchayat hobe, bracket e Panchayat korbe, additional district magistrate Panchayat, requested the block development officer to seek clarification from the concerned Pradhan. However, though departmental proceedings has been initiated against the executive assistant, ex-secretary of the Bagrabad Gram Panchayat and Nirman Sahayak, yet no proceedings has yet been initiated against the Pradhan. What was his name?
Respondent number 9.
Against respondent number 9, erstwhile Pradhan.
Mastara Khatun.
Astara Khatun. Mastara, na? Mastara Khatun.
MST.
Mr. Lalit Mohan Mahata, learned advocate for the state respondents, submits that a direction be issued for filing a report by the block development officer on affidavit. Learned advocate representing respondent number 9, Mastara Khatun, and respondent number 10 also seeks to file affidavit in opposition. State respondent is directed to file report in the form of affidavit within 2 weeks. Advance copy be handed over to learned advocate for the petitioner. Exception, if any, be filed within a week there. No, advance copy be handed over to learned advocate for the petitioner. Exception, if any, be filed within a week thereafter. Similarly, affidavit in opposition is same direction there. Respondent number 9 and 10. ठीक है. List this matter after 3 weeks under the heading written in motion. Mr. Mahata, you annex this in the report also. This, your order. Chalo. Thank you, sir. Okay.
নাম দিয়ে দিচ্ছ তো? নাম দিয়ে দিচ্ছ?